Yeah, please go on.
Yes.
So this matter, the civil engineer matter, I filed a petition tomorrow, my lord.
May I please, your lordship? There is an urgent matter I have filed yesterday, my lord. Non-calling of the petitioners to the written test after the medical test, physical test of your lordship is taken one matter yesterday, my lord. And fix it tomorrow. It may be taken also together also same parties, sorry, same respondents, same notification, same decision, my lord. May it be
Oh,
taken.
motion.
Motion, my lord.
Yes.
Like,
Supplementary list for motion, I think.
May it please the lordship. My lord, in the tax department, now the authorities are proposing to make promotion to the grade of inspector. Now, earlier, my lord, as per the earlier rules, even a non-graduate could have made it. Now, my lord, the rules were amended in 2020. Now, my lord, it is only graduate who can make it. Now, the relevant amendment, lordships will get at page number 31, my lord.
Who is for the respondents here?
What do you have? Finance taxation at page 35, my lord.
Page 35. Yes.
Amendment of Rule 11. In principal rule in Rule 11, in sub-rule F, in between the word statistical assistant and must have secured qualifying marks, the punctuation mark and the words must be a graduate or possessing equivalent degree from any government recognized university shall be inserted. So henceforth, my lord, it is only a graduate who can be eligible for appointment, a promotion. Now, my lord, an exercise was undertaken earlier when a list of candidates who were not eligible was published, my lord. Now what had happened, the government has published a list which your lordships will get
Yes.
at page number 95. No, 95 would be in order. No?
Yes.
Now, please come to page number 95, Mila.
Yes.
In continuation of his office order dated 1/3/25, it is hereby informed to all concerned that the date of departmental written test for promotion from cadre of ministerial staff to inspector of tax shall be conducted by this commissionerate as per date and venue time mentioned below. Now it is on 6/4/25. Now who will appear, my lord? The persons who are not graduates. Now that list, lordships will get at page number 39. Page number 39, this is the list, my lord. Now we have shown at page 46, my lord, to 49, we have shown who are overaged candidates, and page 52, we have shown who are unqualified, underqualified candidates. Now the issue is, my lord, now possibly the state is relying on the decision of, my lord, their Rangaya. That now, my lord, Rangaya's decision has been overruled, lordship knows that. Now the recent decision of the Supreme Court, we have annexed it. If your lordship will kindly come to page 83. It's a part of the judgment, my lord.
Yes.
In a recent decision in state of Himachal Pradesh versus Rajkumar, after reviewing a number of decisions on the same subject, this court formulated the following principles. A review of the 15 cases that have distinguished Rangaya would demonstrate that this court has been consistently carving out exception to the broad proposition formulated in Rangaya. The findings in the judgment that have a direct bearing on the proposition formulated by Rangaya are as under. There is no rule of universal application that vacancies must be necessarily be filled up on the basis of the law which existed on the date when they arose. Ranga's case must be understood in the context of the rules involved therein. It is now well settled proposition of law that a candidate has the right to be considered in the light of the existing rules, which implies the rules in force as of the date of consideration takes place. The right to be considered for promotion occurs on the date of consideration of the eligible candidates. So Rangaya has been, my lord, overruled. And now the preponderance of judicial view is whatever rule is in force on the date of consideration, that will govern the selection, promotion, etc., etc. Moreover, my lord, lordship knows there are a line of decisions starting from that 1975 Constitution bench, where Supreme Court has said, my lord, when it comes to promotion, a higher qualification can always be prescribed. I'm just placing that judgment for lordship's kind consideration. It to 1974 1 SCC 19.
Yes.
My lord will kindly come to para 33 at page 33.
Yes.
Just from this point of view, it seems to us impossible to accept the respondent's submission that classification of assistant engineers into degree holders and diploma holders rests on any unreal or unreasonable basis. The classification, according to the appellant, was made with a view to achieving administrative efficiency in engineering service. If this be the object, the classification is clearly correlated to it. For higher educational qualification are at least presumptive evidence of higher mental equipment. This is not to suggest that administrative efficiency can be achieved only through the medium of those possessing comparatively higher educational qualification, but that is besides the point. What is relevant is that object to be achieved here is not a mere pretense or an indiscriminate imposition of inequalities, and classification cannot be characterized as arbitrary or absurd. That is the furthest that judicial scrutiny can extend. Now, if your lordships would kindly come to paragraph 50, my lord.
Paragraph 15 of the hit.
50, my lord, at page 40. We are therefore of the opinion that though persons appointed directly and by promotions were integrated into a common class of assistant engineers, they could, for the purpose of promotion to the cadre of executive engineer, be classified on the basis of educational qualification. The rule providing that graduates shall be eligible for such promotion to the exclusion of diploma holders does not violate Article 14 and 16 of the Constitution and must be upheld. Now, here in this case, my lord, there were diploma holders and degree holders both integrated into the grade of assistant executive engineer. But when it comes to promotion to the grade of executive engineer, they said it is the graduate engineers alone who will be promoted. That was put to challenge, which Supreme Court says no, nothing being. At least, so therefore, my lord, coming to the facts of the present case, the rule has been amended. Rule says graduation is required. Now, how after amendment of the rule, my lord, they can go ahead with a selection process that to purport to promote persons who are not graduates. So that is under our challenge, my lord. And on 6/4, they are going to finalize that promotion process. Therefore, in my humble submission, my lord, unless they satisfy whatever it is. But since they do not have the eligibility, where is the question of considering their case? So that should be interdicted.
So there is an order of 28/3/2025.
Well, they are supposed to produce that list.
No, but here the projection, is it the correct projection that the petitioners are being excluded? Is that the projection?
Yes.
Why is
I
it
don't
so?
know. We don't know, Milord. On the contrary, we should have been included, the others should have been excluded.
My lord, here, my lord, there are only 60 vacancies. So against that, at the ratio 1:4, this list have been prepared. Yes, admittedly, my lord, there are undergraduates in this list as well as graduates. Since, my lord, the cutoff, my lord, of 1:1:4 ratio was over, the petitioner, though graduate, my lord, their names are not there in the list.
Right, but
Now, my lord, the decision is
the
this,
rules
my
have been amended and now.
Yes, on my lord, most in December 2020, it has been amended.
Hmm,
That lordship will find, my lord, that amended part in the writ petition.
hmm.
It is at
So,
page
so
35.
if you amended the rules in twenty
Now, my
twenty,
lord, yes, now what has happened is, my lord, at that point of time when the amendment was made in 2020, a drive was initiated by the department for
Hmm.
filling up of 60 posts which were vacant at that point of time,
Hmm.
till the amendment, my lord. And 140 numbers were there in the list, who were only graduates. Now, my lord, at that point of time, the various applications were submitted by those, my lord, persons who are already there in service and are working for a long time as a upper division assistant or, my lord, other posts, who otherwise was qualified prior to the amendment. They sought for a one-time measure at least so that they can participate.
You have to
No, I'm
make-
just saying what is the
do it in
40%.
rules. If you want to do it, you do it, but you have to do it. in
So
the
a
rules.
decision was taken that, my lord, as a one-time measure. It is reflected in the speaking order passed in a, my lord, earlier writ petition filed before this honorable court,
Hmm.
where, my lord, similar situated persons approached the honorable court challenging that, my lord, in the subsequent list of 240, their names are not there, though they are graduate. So there the speaking order was passed and this one-time measure is reflected. It is part of the writ petition. And I have also the letter by which, my lord, that exercise was carried out. And in fact,
What
that
is the petition, which page?
yes, my lord. Lordship will find it, it starts at page, my lord, 60, 59, my lord, 59. This order was passed, my lord, pursuant to the order dated 10/6/2022, passed in WPC number 3845 of 2022. Lordship will find at page, my lord, 61,
Yes,
the last second para, page 61. This is
Hmm.
the final.
yes.
In respect of all future vacancies, the ministerial staff having graduate degrees will only have the eligibility to appear in the departmental examination for promotion and page 61. Hence, their interest is not prejudiced by a one-time opportunity given to all ministerial staff, whether graduate or otherwise. That decision, my lord, I have placed, my lord,
Is this under challenge? This
is not under
is not
challenge.
under challenge.
Not under challenge. In
Not
fact, my lord, those, my lord, undergraduates are also not party in the present, my lord, proceeding. That is the communication, my lord, and these are the various opinions that were sought for
So
from
now, how many vacancies are there? 60.
60.
When did these vacancies arise?
My lord, it was till the amendment, my lord, December 2020, 60. And that process has not been finalized till date, my lord. So again, my lord, we have initiated this process now in 2025 by the impugn order.
And where is the order of the court, 10/6/2022?
Yes, my lord. That lordship you will find at page, my lord, operative page 56, operative part, page 56. It starts, my lord. In the very first para, it says the petitioners are graduates and as such qualified to be promoted to the next promotional post of Inspector of Taxes. So since their name did not figure among the 240, so they approach this honorable court. Para 6 and 7, my lord, is the order. In the next page.
Yes, what is this?
Well, that is the opinion that was sought for, or views from the personnel department. They also had the same view that one opportunity should be given, my lord. At the bottom is the, my lord, opinion of the personnel department dated 8/10/2021. And in the next page is the opinion of the judicial department.
So, Mr. Chaudhary, is
Lord,
this order under challenge?
No, what I'm
Connection-
saying, my lord, this process was never taken to logical end. Now they have started afresh.
Again, yes.
No occasion to challenge because my lord, they have not taken that decision to its logical end. Now they have started afresh. Now, Lordship will kindly see at page 61.
No,
This
just
order was
1 minute,
passed-
just 1 minute.
Ah,
You are saying that this order at page 59
yes.
has got nothing to do with the
No,
present
no,
process.
no, what I'm saying is, my lord, though this decision was taken,
Hmm.
but it was not carried forward. They did not initiate any promotion process pursuant to this. Now they have started. Though they proposed to do in this fashion, my lord, but this was not pursued. That's why we did not challenge. Now they are coming up with their proposal. And at page 61, this was based on Ranga's decision. Ranga stands overruled.
That's correct. So
Yes.
what I am asking is,
Yes,
according to you, this speaking order of 7 July 2022
yes.
has nothing to do with
Because
this notification.
pursuant to this, no action was taken. Or they never started with any promotion process. Now they have taken. Now, when they are proposing it now, therefore, my lord, the amendment is there. Ranga stands overruled. So how can they go stick to that old
So
stand?
therefore, the only issue that is relevant here is
Yes.
whether this 21(6)
Yes,
has got any bearing with this.
Yes.
If the answer is yes, then petitioners won't have a case.
Huh.
If the answer is no,
No.
then the matter has to be examined.
yes.
So you file an affidavit clarifying this.
Lordship. In fact, my lord, the judgment that has been relied upon by the, my lord, petitioner side.
You will do judgment later, first the facts.
Yes, I place it, my
First the
entire, my lord,
facts.
fact.
You have to demonstrate before the court
Lordship.
that
Otherwise, my lord, those, my lord, undergraduates, my lord, they will be left without any professional avenue because of that. Of course, my lord, this is a government based second time.
that is another matter.
Lordship. As a one time
What
measure,
Mr. Chaudhary is saying is that this order of 21/3/2025
my lord.
has got nothing to do with
The
the
present
speaking
exercise.
the speaking order.
No, my
Yes,
lord.
issue- yes,
Then I will file my affidavit. my
Seven.
record.
7/2022.
It has got a bearing. my lord. In fact, my lord, in that particular order, this one time measure has been reflected. And that exercise has been now carried out, my lord. In between, my lord, the
No,
judgment has come up.
There is
It's
no
the fact.
question of being hyper technical. If you have not challenged it, you can also put to challenge this or I am not on that.
Right.
What I'm trying to say is, my lord, this exercise which they took in July 2022, it was never taken to its logical end. Therefore, the occasion did not arise. Now in 2025, they are purporting to go ahead. That's why we are before your lordships.
Right.
If they would have come forward, then we would have definitely challenged it.
That's why, my lord, it should have been challenged because now they have put it in the affidavit, in the writ petition as an annexure, but it has not been put to challenge, my lord, this decision.
All right.
It's
you
within
file
the
your
policy.
affidavit. File your affidavit.
Only thing is, my lord, on 6/4, they should not take any final.
So we'll ask them to go ahead with the process, but not pass any final order
Yes.
without the leave of the court. You file your affidavit. When did you
Lordship.
file it?
Why immediately after, my lord, reopening, my lord. I will-
Yeah, suggested date.
Kindly see, my lord,
Hmm.
22nd of May,
Mhm.
Rangaya judgment was overruled.
Right.
And on July, my lord, this order was passed.
No, we'll
Relying on.
we'll examine that.
Yes. No, just as a point of information, my lord, 22nd of May, Rangaya overruled. And in July, my lord, this order was passed, relying on Rangaya.
Done.
And my lord, we should also be allowed to participate, my lord.
No, Mr. Chaudhary, either the whole process will be scrapped
Ah,
or it will stand.
Yes.
If it is scrapped, your clients will automatically come in.
yes.
But at
Okay.
the moment, beyond that, it will be difficult.
My-
We'll ask them not to pass any.
Proceed, yes.
My-
fine.
You take down heard Mr. K. N. Chaudhary, Learned Senior Counsel, established by Mr. B. Professional and Counsel for the Writ Commissioners. Also heard Mr. B. Gogoi, Learned Additional Advocate General, Assam, appearing for the Finance.
By
and Tax-
23, I will file the affidavit.
Finance and
Lordship,
Taxation.
kind permission, can I take leave?
Finance and Taxation Department. For all the respondents. You are appearing for all the
My
respondents?
lord.
Yes. The petitioners herein are working as assistant inspectors. And they are all graduates, full stop. Pursuant to the amendment of the amendments carried out to the Assam Taxation Service bracket amendment. No, pursuant to the Assam Taxation Service bracket amendment bracket close rules, 2020. The minimum qualification for promotion of statistical assistants to the next higher rank of inspector is graduate or equivalent degree. First step. The grievance of the petitioner is that by issuing the impugned order dated 21/3/2025, the respondents have permitted undergraduates to take part in the departmental written test for promotion of ministerial staff to inspector of taxes, as a result of which eligible and graduate candidates such as the writ petitioners have been precluded from participating in the departmental examination. Full stop. Mr. Chaudhary has vociferously argued that although the decision of the Supreme Court in the case of Rangaya, into citation to लिखी दो. Can you give the citation of Rangaya's decision has been overruled? Yet the department has erroneously followed the principle laid down in the said decision and thereby permitted ineligible candidates to take part in the departmental examination for promotion to the post of inspector. Mr. Chaudhary has therefore prayed for an interim order restraining the respondents to go ahead with the process and in the alternatives, issue a direction to allow the petitioners to take part in the written test. Full stop. Responding to the above arguments, Mr. B. Gogoi, Leonard Additional AG Assam, has submitted that the undergraduate ministerial staff have been permitted to take part in the departmental examination on the strength of order dated where is the order? 21/7/7, is it?
Yes, ma'am.
Which page is it?
15 and
My then order the this honorable court, man.
No, the
Page
order.
59.
The one-time measure.
One-time measure is not there in the writ petition, my lord. In the speaking order, it is there.
It is
Yes.
there, just
Yes.
now I saw it.
By 61. Page 61. Part of the speaking order will start from page 59.
Order dated 7/7/2022, bracket annexure 8, which was issued in terms of the order of this High Court dated 10/6/2022 in WPC number 3845/2022, whereby as an one-time measure, the undergraduates were permitted to take part in the promotional process. Full stop. Mr. Gogoi submits that since the speaking order dated 7/7/2022 is not under challenge, and considering the fact that the department has taken a conscious decision to go for a one-time measure so as to give benefits to the undergraduate departmental candidates, this writ petition is not maintainable. Full stop. The learned additional advocate general Assam has therefore prayed for time till 23rd.
My lord, 23rd of April.
23rd of April to file affidavit bringing those facts on record. In view of the above, issue notice of motion returnable on 5th of May 2025. Since Mr. Gogoi has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to Mr. Gogoi within 3 days from today. Mr. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that the departmental authorities will be at liberty to go ahead with the process in terms of the impugned order dated 21/3/2025, but they shall not issue any final order of promotion to the post of inspector without the leave of this court. First of all, it is further made clear that the process so undertaken shall be subject to the final order that may be passed in this writ petition.
Problem. Well, the petitioners are, my lord, they are senior assistant, not, my lord, assistant inspector of taxes. They are senior assistant.
The writ petitioners and senior assistants.
Ma-
Yes,
Wait, please, my lord. It's- sorry, sorry.
yes.
Yes, my lord. My lord, my humble limited prayer is that I may be allowed to continue because I have been serving for since 2016 as helper in this particular Anganwadi center. And I have been continuing, yet this advertisement dated 6/3/2025 has been published against my post. Although I'm serving.
Yeah, Lordship, I've just given the instructions. Basically, right now I'm in a very dichotomous situation because the directorate is saying something and the CDPO is saying something else.
You file your affidavit then. Let him file his affidavit. You are Miss P. Devi.
P. Devi. My lord, then my humble prayer would be till then, till the filing of affidavit, my service may be protected and till the next date.
She is still serving.
She is still serving. Directorate says that she is still serving and the CDPO says that she is not serving. So, and she has not been paid her salary since 2018. And director says that she has not been paid. The CDPO says that she has not been paid because she is not working.
All right. Heard Ms. P. Devi, learned counsel for the petitioner. Also heard Mr. D. Bora, learned government advocate Assam, appearing for the respondents who submits that he has received instructions and therefore be granted 4 weeks time to file affidavit. Responding to the above, the petitioner's counsel submits that her client is still continuing to serve as helper in 437 number Paschim Kalvari Anganwadi Center under Bhurvanda ICDS project, and therefore till disposal of the writ petition, her services may not be disturbed. The said claim of the petitioner's counsel could not be convincingly dislodged by the learned government advocate Assam. In view of the above, as an interim measure, it is hereby provided that if the petitioner is still continuing in service, her services as Anganwadi helper shall not be disturbed until further orders. The respondents may file their affidavit within 4 weeks by serving advance copy upon the petitioner's counsel.
Highly obliged.
For admission, Club of Delhi, item 19.
May please, your lordship.
Yes.
The petitioner before your lordship is aggrieved by his prolonged suspension. That too on unjustifiable grounds, my lord. Lordship will kindly,
Please give the facts.
yes, my lord, petitioner was suspended under Rule 6(2) of the Assam Services Disciplinary Rules, 1964, on 27/1/2024. Annexure 1, page 27 of the writ petition.
Let us see the order.
Yes, page 27 of the writ petition. The last two para, whereas as per Assam Services Discipline and Appeal Rules 1964, under Section 6(2), a government servant who is detained in police custody, whether on criminal charge or otherwise, for a period exceeding 48 hours, shall be deemed to have been suspended. In view of the above facts, Sri so-and-so Supervisor Kanangu, Office of the Circle Officer, Samaria Revenue Circle is hereby suspended with effect from 5/1/24 until further order.
Yes.
Yes. Thereafter, my lord, on 7/2/2024, he was released on bail by the Learned Special Judge Assam. The bail order is your lordship at page 36.
Yes.
Then, my lord, a so-called notice was issued on 3/4/2024. That your lordship will find at page 37. 39, page 39. On 3rd of April 2024, so-called notice was issued initiating disciplinary proceeding, page 29. Petitioner submitted his written statement on 12/4/2024, my lord. That is at page 44.
Page?
12/4/2024, WS was filed, page 44 to the writ petition.
Yes.
Yes. Thereafter, my lord, an inquiry officer was appointed and the departmental inquiry commenced. And in the meantime, Lord, will kindly take note of the dates. The first review of the suspension was carried out on 8/4/2024. Then the second review was carried out on 11/7.
First review was on?
On 8/4/2024, page 43 to the writ petition. Second review
Yes.
on 11/7/2024, page 48 to the writ petition.
Page 47.
Page 48. 11/7/24, second review of the suspension.
Yes.
Yes. And third review was carried out on 4/11/2024.
Page?
56 to the writ petition.
Yes.
And fourth review was carried out on 11/1/2025. That is page 74 to the affidavit in opposition.
Yes.
Yes, and in the meantime, Lordship, this is very important. On 29/10/2024, the inquiry officer completed his inquiry and submitted the report to the disciplinary authority. That is reflected in the affidavit in opposition.
What is the date of the report of inquiry officer?
29/10/2024. That means the fourth and the third and the fourth review are subsequent to the report submitted by the inquiry officer. Right. Lordship will kindly peruse all the extension, the review orders are ditto copy pasted. Lordship will kindly the third review, which is at page 56 of the writ petition.
Yes.
May I read it, my lord?
Yes, yes.
I am reading the third para from the top. Therefore, considering smooth completion of the departmental proceeding, undersigned further extended the suspension period of Pradeep Kalita, so Samaria Revenue Circle, with effect from 5/10/24 until further order. So the reason cited in the review or the extension order is for smooth completion of the departmental proceeding. No other reason. And in the fourth extension, that is 11/1/2025, at page 74 of the affidavit in opposition, Same very ground is taken, my lord. Lordship may peruse. Page 74 of the Annexure D,
Hmm.
affidavit in opposition of the department. Third para from the top.
Yes.
Therefore, considering smooth completion of the departmental proceeding, undersigned further extended the suspension of Sri so until further. Yes.
So according to you, what is wrong about
Yes,
this?
yes, Lordship, I'm just before making my legal submissions, Lordship will also kindly peruse para 13 of the affidavit in opposition at page 68. Para 13 at page 68. May I read it, my lord?
Yes.
That with regard to the statement made in paragraph 14 of the writ petition, the deponent respectfully states that the departmental inquiry has been completed and the inquiry report has already been submitted to the higher authority of the deponent, that is respondent number 1, on 29/10/2024 for necessary concurrence in compliance with the letter dated so and so, so and so, so and so. So it is the categorical stand of the authorities that the inquiry report has been submitted on 29/10/2024, and then it is awaiting, my lord, the decision of the disciplinary authority. Now, I am into my 15th month of, my lord, suspension.
Yes.
Lordship knows there is a departmental manual, and as per clause 2.1.4 of that manual, it stipulates certain grounds on which a person is to be suspended, my lord. I will refer to that. Lordship will kindly peruse that.
So have they given you a copy of the inquiry report?
No, because inquiry officer will not give me the copy of the inquiry report.
No, this
Before a decision is taken, the disciplinary authority will give me a second so-called notice, including that says no, has not yet come, my lord. But they're keeping me under suspension, and my lord, the reasons for suspension are enumerated in clause 2.1.4 of the departmental manual. Plus, will kindly peruse that. Whether any of the reasons or grounds enumerated in clause 2.1.4 is present in the instant case. If not present, then my lord, the impugned suspension or a prolonged suspension takes the color of a punishment, my lord. The suspension, as your lordship knows, is a part of the process in the endeavor of the employer to know the truth. But the process itself cannot be turned into a punishment, my lord. That cannot be. It is only after departmental proceeding a punishment can be imposed. But by keeping me unduly under suspension, they are turning the process itself into a punishment, my lord. That is my humble submission. But you will kindly peruse clause 2.1.4 as at page 58 of that book, my lord. It is the own profess norms 58 of the book, my lord.
Yes.
Clause 2.1.4. May I read it, my lord?
Yes.
Although suspension is not a punishment by itself, it cannot be denied at the same time that in such cases, the officers placed under suspension suffer a lot. Apart from this, suspension of a government servant is a liability on the part of the government. The idea behind placing an officer under suspension is not to inflict punishment, which can be done only when the charges are proved, but to safeguard against further loss to the government, manipulation of records, intimidation of witnesses, or embarrassment to the government in the public eye, as in the case where moral turpitude is involved. So these are the broad grounds, my lord, stipulated in this clause. In all cases, the suspension, the elementary justice demands that the period of suspension should be reduced to the barest minimum. It is therefore necessary to conclude proceedings drawn up quickly as possible, and in any case, if it is not possible to do so due to reasons beyond control, the persons proceeded against may be allowed to resume their duties where possible in places away from their former place of duty, vacating the suspension order so as to save government expenditure in the event of its equity.
Where is the charge sheet?
Yes, well, the charge is at page 74.
Page 74.
No, my lord. Oh, sorry. Space 37, 39 to the writ petition.
So what has happened to the criminal proceeding?
My lord, trial is going on. Charge is not been filed. Lordship, may I just point out since the lordship has.
Charge, you're saying trial is going on.
No, my lord, I stand corrected. I am instructed that in the criminal case, charge sheet is yet to be filed. Investigation is going. Since the lordship has referred to it, may I just point out, on the day of my arrest, as your lordship knows, in the case of my lord accepting bribe, both demand and acceptance has to be proved. The money, rupees 3,000, was recovered from my lawyer and no fellow-tending test was done. So there is no proof that I accepted the tainted money, my lord. So there is every chance of acquittal in my case. They can relate. It was only lying in my.
That's all right. That's in the criminal.
Yes, that is the criminal case. So, my lord, my submission before your lordships today is, I am in my 15th month of suspension. Enquiry is completed. There is no question of intimidating any witness, tampering of evidence, or causing further loss to the government. In fact, my lord, they are paying me sufficient allowance. The state executive is burdened without taking my lord, manpower resources is being unutilized, my lord, but still they're paying. And lordship, on this point, I would like to place one judgment. You kindly take up 2017 3 GLT. The cashier of the office of the deputy commissioner was, my lord, under similar circumstances placed under suspension. Enquiry proceeded, and after hearing, nothing was done. Then, my lord, relying on this clause 2.1.4, this honorable court, my lord, vacated suspension order. Lordship will kindly come to para 4 for the facts. I will rely on para 9 and my lord para 11. May I read the para 9, my lord?
Yes.
I'll start from the para 4, my lord, the facts. The petitioner against the suspension order filed his representation with the said authority, but the authority concerned proceeded to appoint an inquiry officer and a presenting officer by letter dated so and so. Pursuant to the appointment of the inquiry officer and the presenting officer, a series of hearings was conducted whereby the petitioner was summoned to appear before the inquiry officer, and the last appearance being conveyed on 1/4/2015. The learned counsel for the petitioner submits that the last hearing was conducted on 7/4/2015, but however, the authority, without taking any further decision, have not taken any action. And in the meantime, the petitioner is still under suspension pursuant to the suspension pardon so and so. But the rest I will skip. But will kindly turn to para 9. The learned counsel for the petitioner has drawn attention to this court to paragraph 2.1.4 of the Assam Services Discipline and Manual Rules 1964. The said provision may be reproduced below for ready reference. Lordship, I have just read out. I will not read this. And para 11, my lord. I have considered the libel submissions of the parties, providing further opportunities to the learned government advocate to obtain instruction may not result in persuading this court to take a different view than what has been laid down in the aforesaid decision. As noticed, the petitioner has been in suspension since 3/11/2014, and it is well over 2.5 years now that the respondent authorities have been unable to conclude the disciplinary proceedings. In such circumstances, I find no justification for the prolonged suspension of the petitioner. Even if the disciplinary authority ultimately decides against the petitioner, there is no reason as to why the petitioner should be kept under suspension awaiting such final decision. Upon considering the materials available on record, as well as the decisions rendered by this court and the apex court in similar context, this petition is disposed of with a direction to the respondent authorities, more particularly respondent number so and so, to reinstate the petitioner back into service within 15 days from the date of the receipt of the certified copy of the service. On a similar facts, my lord. And there is a division bench judgment, in fact, several division bench judgments, which says prolonged suspension without any justifiable reason takes the color of punishment, my lord. That's a major space, one paragraph of a division bench judgment.
Show the latest one.
Latest one, 2019 5 GLT. Page 444. Lordship will kindly come to paragraph 15, 1-5, at page 451.
Paragraph
15. At page 451. These are division bench judgment, madam. May I read it, madam?
yes.
The state government definitely has the power, authority, and jurisdiction to keep a government servant under suspension pending trial of a disciplinary proceeding or during the pendency of a disciplinary proceeding or during pendency of a criminal investigation, inquiry, trial. The object of placing a government servant under suspension is to keep him away from an influential position wherefrom he can interfere with the conduct of the disciplinary proceeding, pending or contemplated or criminal investigation, inquiry, trial, so as to prevent him from hampering in the process of collection of evidence or from tampering with the evidence in any manner, or where, having regard to the nature of charges, allegations against him, the competent authority is of the opinion that it would be unsafe to continue to vest him the powers of the post of government servant is occupying. It is for the competent authority to consider all these aspects at the time of placing the government servant under suspension and also during the period of suspension, to a period of subsequent suspension for keeping him under suspension. And this is very important. At the same time, on the other hand, the placement of government servant under suspension for prolonged period unduly would change the color of measure taken to place the public servant under suspension with the aforestated objectives into a measure of punishment. So Lordship has seen the extension orders. It is only for smooth completion of the departmental proceedings. Already, my lord, the inquiry officer has examined, he has submitted his report. So where is the question of petition of, my lord, interfering with the process, tampering with the evidences, or influencing the witnesses, my lord? So, in my humble submission, any further continuation of the petition of suspension would be arbitrary and it would be in the realm of punishment, my lord. So Lordship will kindly interfere and quash the suspension order and direct reinstatement. And they can place me somewhere else, my lord, that is always there. That is my humble submission, my lord. I reserve my right to reply.
In this case, I'm appearing for number 1 and 2, Lordship.
Respond numbers 1 and 2.
1 and 2. 2 have filed an affidavit. Regarding their factual aspect, there is no dispute, Lordship. When suspension order was passed, when review was taken. Only because of the annexer F of our affidavit and page 76.
Yes.
Personnel department has issued an circular, Lordship, to all administrative department that may have read it, Lordship. With reference to the subject cited above, I am directed to inform you that pending finalization of and issuance of an office memorandum on the matter, henceforth all disciplinary authority under the government of Assam shall obtain the approval of the Honorable Chief Minister of Assam prior to acceptance of the inquiry report and disposal of the department proceeding arising out of the trap cases conducted by police authorities and arrests made by police authorities for committing illegalities while performing government duties. Only because of this this communication, Lordship, that the decision is pending before the higher authority, Lordship.
That's all right,
Right.
but then what is your answer to his plea that by prolonging it, you are penalizing him?
Lordship, that is
He is the one suffering because of your departmental
not only he
malfunctioning.
suffering, but department also suffering. That is factual aspect, Lordship. That is, we have to admit. Otherwise, Lordship, is relying departmental manual 2.1.5 clause, 2.1.4.
Four, yes.
I am relying 2.1.5 and 2.1.7. Certain condition has been laid down where government can use their discretion, Lordship. 2.1.5, Lordship.
Hmm.
By way of clarification of the general principle enunciated above, the following circumstances are indicated in which disciplinary authority may consider it appropriate to place government servant under suspension. These are only intended for guidance and should not be taken as mandatory. One, cases where continuation of the government servant will prejudice the investigation, trial, or any inquiry.
So which clause applies to this case?
Lordship, 2.1.7, Lordship. Certain types of misdemeanor where suspension may be desirable in the circumstances mentioned above are indicated below. Any offenses or conduct involving moral turpitude. Second one, Lordship, corruption, embezzlement, or misappropriation of government's money, possession of.
That's all right, but
That's
the
it.
question is not whether you can suspend him or not. The question is, what is the justification for keeping him under suspension today? That is the core issue.
Lordship.
What is your answer to that?
My submission also would be, Lordship, since the inquiry hasn't concluded, Lordship may direct the department proceeding to conclude that DP within a time frame, Lordship.
No, why should we? That's
Otherwise,
not the
Lordship,
prayer.
Otherwise,
That
Lordship,
is not the prayer.
Lordship,
The prayer is, will not go to any other area where it is not required. The only question is asking you,
Lordship.
why have you please continued my suspension?
apparently
Answer
no,
that.
apparently no reason.
Then take your seat.
Otherwise, Lordship, I'm
There
praying.
is no reason, then take your seat.
I'm praying. I'm referring one judgment, Lordship. Scope of interference by court in suspension matter, Lordship. That's it.
Nothing will work unless you say that this is the justification. Then you can say that the scope is limited. You can't say we have no justification, but you don't have the power to interfere. That argument will not hold good in this court.
Otherwise, Lordship,
Mr. Datta,
Lordship,
are you understanding what the
Lordship,
court is
Lordship,
saying? You cannot say that, sorry, we don't have any justification. We are making a mistake, but you cannot go into it because our discretion. That argument you cannot make.
No.
So unless you give the justification, rest of the arguments you cannot make. Because there are already authorities which say that the
Otherwise,
suspension.
in a recent judgment, Lordship, recent judgment, it is this is reported in AIR 2022 SC 1618, Lordship.
What does it say?
Page 51,
161.
161.
Paragraph 50, Lordship.
Paragraph?
50, 50, 51, and 53, Lordship.
Yes.
Insofar as prolonged suspension of respondent number 1 is concerned, the respondent number 1 has relied on the judgment of this court in the cases of Ajay Kumar Chaudhary and State of Tamil Nadu, represented by by the Secretary to the Government of Home versus Pramod Kumar IPS, reported on so and so. Insofar as the judgment of this court in the Ajay Kumar Chaudhary is concerned, though this court has depreciated the protected period of suspension and repeated renewal thereof. In the facts of the said case, this court found that since appellant therein was served with a search sheet, the discretion used in the said case may not be relevant to him any longer. Insofar as the judgment of this court in Pramod Kumar is concerned, this court has observed that there cannot be any dispute regarding the power of jurisdiction of the state government for continuing the first respondent under suspension pending criminal trial. There is no doubt that allegations made against the first respondent are serious in nature. However, the point is whether the continued suspension of the first respondent for a prolonged period is justified. In the said case, respondent number 1 therein was suspended for more than 6 years. This court found that no useful purpose would be served by continuing the respondent number 1 therein under suspension any longer. Para 53, we find that the present case, it is a respondent number 1 who, though called upon participate in the departmental proceeding, has on his own chosen not to participate therein. It is the respondent number 1 who had objected to initiation of the departmental proceeding by the commissioner on the ground of jurisdiction and refused to participate in the departmental proceeding. We therefore find that respondent number 1 cannot be permitted to take benefit of his own wrong. In any case, we find that the issue of prolonged suspension would be taken care by directing the departmental proceeding to be completed within a stipulated period, but the suspension of respondent number 1 would continue till then. We find that the impugned judgment of the judgment passed by the High Court is not sustainable in law. In a result, the appeals are allowed in the following terms. The impugned judgment that is so and so passed by the High Court of Judicature at Bombay in the writ petition number so and so is quashed and set aside. The writ petition number so and so filed by the respondent number 1 before the High Court of so and so is dismissed. The departmental proceeding initiated against respondent number 1 are directed to be completed as expeditiously as possible. In any case, within a period of 4 months from the date of this judgment, the respondent number 1 would continue to be under suspension till the conclusion of the said department proceeding. My submission will also relying this judgment. Ultimate is direct the department authorities to conclude the DP within a time frame. This is recent judgment.
That's all. Yes,
Yes, my lord, short reply, my lord. What I can gather from the judgment, that departmental proceeding was not concluded. There meaning thereby, the chances of tampering with evidence or influencing the witnesses, they are
No,
still there.
just a minute, just a minute. Do you have this manual with you?
Yes, yes, my lord.
Can you please come to Rule 6,
Yes,
which deals with suspension?
yes, my lord.
Come to Rule 6C.
Yes.
Does your case come under Rule 6C?
Rule 6.
C.
Oh, no, my lord. This is rule 6, 1C. I was suspended.
That's
under-
right, 1C, 1C.
Yes. Where a case against him in respect of any criminal offense is under investigation, inquiry or trial. Yes, my lord. But my suspension was under Rule 6.2, not Rule 6, 1C, my lord. Lordship can peruse my suspension order at page 27. And Lordship will also kindly see sub-rule 5.
Mr. Patwari, you see, there is a very subtle area here. Please try to understand the query.
Yes, my lord.
Rule 6.1 deals with the grounds on which the authority can place an employee under suspension.
Absolutely, my lord.
One of the ground is 1C, where a case against him in respect of any criminal offense
Yes,
is under investigation, inquiry or trial.
true, my lord.
Now, technically,
Hmm.
there is a case of criminal offense which is under investigation against your client.
True.
So technically, 6.1C permits them to continue in suspension because there is a criminal investigation under progress against your client, correct?
My lord.
Now, please understand,
Yes,
if you
yes.
don't answer the query, then
Yes, I will answer, my lord.
I'll write my judgment in the chamber.
Yes, my lord.
This, I want to know what is your
Yes, my lord.
response to these.
Yes, my lord.
Because you have made some very formidable arguments,
Yes, my lord.
but the court has to take care of all angles.
Yes, my lord.
Now, your client's suspension is definitely under 6.2,
Yes,
correct?
yes.
So are you saying that if the suspension is under 6.2,
Hmm.
6.1 will not have any application?
Yes, because they have to specifically say, so Lordship, kindly see, this rule 6.1C is subject to rule 6.1. What 6.1 says?
No,
That-
Mr. Patwari, please understand the question. 6(2) provides a ground under which your client can be, would have been suspended.
Yes,
That is, if he is arrested and kept in detention for 48 hours.
yes.
Correct?
Yes,
That's one.
yes,
So he was suspended.
yes,
We are now not on what is the ground for suspension.
yes,
We are now on what is the ground to continue his suspension.
yes,
That's the case in you.
yes.
Now, as I said, you have made a formidable argument
Yes.
that if you have placed me under suspension to facilitate a smooth inquiry, then after the inquiry report is
Yes.
submitted, why do you want to keep me
That
under
is the
suspension?
system.
That's a very,
Yes.
but 6(1) also gives them a right to keep you under suspension
No,
when there is a criminal investigation pending.
yes, my lord, but the word used is, my lord, to place me under suspension, not to continue. 6(1) lordship will kindly read. The appointing authority or any authority to which it is subordinate or any other authority empowered by the governor in that behalf may place a government servant under suspension. So these three are also on grounds when which a person can be placed under suspension. But continuation, that is, has to be, there is a review, there has to be a proper application of mind. And whatever may be the ground, the main reason behind suspension is that so that the incumbent could not interfere with the inquiry process, my lord, so that he cannot tamper with the evidence, he cannot, my lord, influence the witnesses or making any further loss to the government. These reasons are not there. Departmental proceeding has concluded. This is one of the another ground to place me under suspension. Not to continue with the suspension, my lord. There is a subtle difference, as the lordship has rightly said. And lordship will also say 6(5) last, my lord. Next page, 6(5).
Yes.
An order of suspension made or deemed to have been made under this rule may at any time be revoked by the authority which made it or deemed to have been made, the order by an authority which the authority is subordinate.
All right. You are appearing for expert numbers
1 and 2.
1 and 2, and anybody else? What about 3 and 4? Mr. J. Patwari for the petitioner, S. Datta for 1 and 2, and Mr. H. Apravar for 3 of. I'm reserving the order.
I'm deeply
All right.
obliged, my lord.
Other matter, I don't have anything.
Just check it. You can get a. Yes,
Actually, yesterday I have submitted a brief note as directed by Lordship.
just 1 minute.
Lordship.
Yes, and you have given a note on the other matter also? Other case also you have given?
Yes.
All right. So let us see, just a quick recapitulation of the facts.
Yes.
Let us see 4972. 4972.
Lordship, 4972.
Yes.
Lordship, the petitioner herein, Lordship, after retirement from our High Court as Lordship Senior Private Secretary with effect from 28/2/2015, Lordship. Then after his retirement, Lordship, he joined in the Armed Forces Tribunal as a Lordship consultant. And the appointment order is at page 20, Lordship, Annexure A. With fixed remuneration of 60,000 initially, Lordship. Page 20.
Yes.
Thereafter, he joined the service at page 23 and access C. The guidelines which has been followed, I have annexed that.
1 minute, 1 minute.
Lots.
13th March 2020.
30th March 2020, he joined initially as a consultant, TPS, Lordship.
Yes.
Then Lordship, initial engagement remuneration was 60,000, then it has been enhanced to rupees 65,000 per month with effect from Lordship 1st February 2022. That has not been annexed, Lordship.
That is not an act.
That is not annexed. But subsequent from it, subsequently it has been again annexed to 80,000 that I have annexed. At 80,000 is at pace.
Annexed to 65,000.
Yeah.
That is from when?
It is annexed from 60 from 1st February 2022. And his Lordship conditions have also been similarly only with 65,000. Then Lordship, Annexure E, page 29. From 1st May, dated 1st June 2022. Here Lordship, it has been annexed from with effect from 1st May 2022. Here Lordship,
Yes.
yes, here Lordship, it is said that the at serial number 1 in the box, Lordship, it is said that deputy registrar or equivalent monthly remuneration will be 80,000, and the deputy registrar is equivalent to PPS. Lordship.
And the fact that he is deputy registered or equivalent,
Yes,
but here it says registered or equivalent.
Lordship, at Annexure E,
No, page 25, come to it.
page 25.
That is the guidelines and procedure for engagement of consultants in the Armed Forces Tribunal.
Lordship,
Here, this is what you have annexed.
yes,
So here the remuneration chart is given.
yes, Lordship.
80,000 is shown as registered or equivalent.
Register, but subsequently, Lordship, this in 22 that has been changed.
22?
That page 29.
Is that correct?
Lordship, it is there. It is their document, Lordship. They are here also, respondents are here.
All right, then.
Lordship. Then he has been, Lordship, receiving that amount of 80,000 from Lordship by the order dated, Lordship, 23rd June 22 at Annexure 31.
Annexure?
Page 31, Annexure Z.
Yes.
From 23rd June 22, Lordship, he continued to receive the same, but had impugned order dated at Annexer L, page 40.
Hmm.
Lordship, they have Lordship, the area accounts office has reduced the monthly remuneration of the petitioner from 80,000 to Lordship 26,270 from July 2024. Also, he filed representation also, Lordship. Representation is there, Lordship.
Where is the representation?
Representation is at page 36. Page 36 is representation, which has been forwarded by the authority at page 38, with clear justification, Lordship, why it has been wrongly. Page 38. May I read this, Lordship, the forwarding?
Yes,
May I read this
yes.
forwarding? This is the from this forwarding by the Lordship Deputy Registrar of the Armed Forces in the Regional Bench, Lordship. The petitioner's representation is forwarded. Sir, with reference to the letters on the subject cited above, I am directed to inform you that the area office Shillong Heights so and so dated 31/7/2021 along with audited salary sheet of
No, you're reading from which page?
page 38. This is the forwarding of the petitioner's representation. Page 38.
Hmm.
Forwarded to the principal registrar, Lordship, Armed Forces Tribunal, principal bench, Lordship.
Yes.
May I read it? With reference to the letters on the subject cited above, I am directed to inform you that area accounts office Shillong White, the number so and so dated 31/7/2024, along with audited salary sheet of consultants for the month of July 2024, copy enclosed Annex A and B, had made deduction of the fixed remuneration of Sri Manavendra Chakraborty, consultant PPS, and Sri Jagannath Datta, consultant JAO, without any notice and justification in the manner as indicated below. By our letter dated 15/5/2024, we had forwarded the reply letter dated 13 July 2024 received from the principal bench, wherein it is stated that both the consultants were engaged after obtaining approval of the competent authority and concurrence of the PIFA, but area accounts office did not consider it. So the table is given. Serial number 2, Lordship. Being agreed, both the consultants as mentioned above have submitted the applications and closed therewith, praying for restoration of the fixed remuneration as per engagement letters issued by the principal bench from that is 80,000 to 48,000 and 48,000 respectively. Next page, Lordship.
So it was brought down by about 53,730,
No,
from
Lordship.
80,000 to
Yes,
26,270.
26,000.
So the difference
That-
was 53,730.
Lordship.
So if your client succeeds,
Lordship.
then he will be entitled to recover this amount as arrear since that date,
Lordship.
and the current should be 80,000. That's your case.
That is the case. And Lordship, he's continuing, this last contract will be over on 25th May, May 2024. The justification given by the authorities is, Lordship, based on one notification, memorandum, Lordship, which is at page 50 of the affidavit of my respondent. The relevant is page 51 plus 6.1.
So it is a self-contradictory clause.
Not,
Why, this says fixed amount shall be admissible
not, sir.
after deducting basic pension
Yes, not.
from the pay drawn by at the time of retirement. Then it says the amount shall remain unchanged from the terms of the contract.
Not, sir.
So terms of the contract says 80,000. How can it be? So if you were to pay a regular salary minus pension, it's a faulty drafting. We'll allow the writ petition. 2 minutes to answer. This doesn't make any sense, and we'll observe that this is completely faulty drafting. Total non-application of mine. You give him regular salary minus pension, understandable. You engage someone on contract basis for 80,000 and then say we'll take out
The
the.
contract is engaged by respondent number 4 and 5. And
Hmm.
I am representing 2 and 3, and I am representing 1, 4 and 5. Our case is that 4 and 5 had exceeded their right, and then this contract lordship, this previously it was there. As per that rule he had annexed in his writ petition, previously it was done by that. But after coming force to this notification 9 December 2020,
Hmm.
this remuneration part has to be considered as per this notification. And then lordship, this next page lordship, Annexure B, page 53, this letter came to all the Armed Forces Tribunal, where it is very clearly stated that the remuneration part has to be taken as per this clause. And so lordship is,
This clause says as per contract. That is what we'll interpret.
there is no annual increment or percentage increase during the contract period. So whatever in that, it was in 2020 lordship, but subsequently lordship 2024.
But she
this
says
letter-
it was, your approval was obtained. It is the last, you given some record?
And-
Approval of whose approval was obtained?
Principal Integrated Financial Advisor, PIFA. Lordship, it is clear from Annexure E also, that approval is. Annexure
Annexure
E of
E.
of the writ petition, it is clear. Annexure E of the writ petition,
Hmm,
page 29.
yes.
This is the enhancement order, which copy was sent to Lordship and copy was forwarded to Principal IFM, means Integrated Financial Advisor of Finance Department, Government of India.
That's okay. Copy sent doesn't mean approval. But if
Yes.
there is a noting in the file, then it is
Yes,
approval.
yes, it is there.
Show it to her once.
The case has been examined, the following common and detailed justification has been adopted. That was said, the following, the articles of the drafting to-
Recovery and financial. So, lordship, so this 80,000, previously it was there. Lordship asked me how we have calculated. So lordship, page 59, his basic, at the time of retirement, his basic pension in first case is 49,331, which we taken as, sorry,
So
46.
where have you mentioned it in the contract? That's what I'm asking you. There is a,
The contract is by 4 and 5, without considering this
take
notification.
action against them.
And
He is not
and one
responsible.
more thing, lordship,
Hmm.
although he had filed this writ petition, lordship, but the notification on the basis of which this impugn order has been issued, lordship, those were not under challenge in these writ petitions. In our impugn order also, we have stated that in terms of those two notifications, this impugn order has been taken. So 80,000 after this remuneration period of remuneration notification was there, lordship. So his basic pension was 46,340. Thereafter, this deducted his basic pension. So the amount becomes
So
26,370.
supposing his basic pension is enhanced to 80,000,
Lordship.
then he will work for 0 rupees. Is that the interpretation?
No,
No, supposing tomorrow, for some reason, the pension of the petitioner is enhanced to 80,000. Then he will work under the AFT for rupees 0.
no,
Is that
no,
the
because
interpretation?
no, it is
Why
not
not?
deducted from contract amount. It is deducted from his basic pen.
So I am saying the contract amount is 80,000. Correct. So tomorrow morning, if your interpretation is to be accepted, Tomorrow morning, if his pension becomes 80,000, then he will continue to serve for 0 rupees, free of cost. Is that
No,
the,
no, because at
then what
the-
will be the amount then?
presently there shall not be any contract amount. Amount has to be as per this remuneration. So yes, Lordship, that is because Lordship it's clear
Ms.
because
Sharma, please give one simple answer. Assume that his pension with effect from 1st of April is 80,000 rupees. According to you, what is the amount of remuneration you will get for working under the AFT?
no,
You
80
answer this, otherwise I will record that you could not answer.
you
Give an
80,000
answer.
cannot be because
Cannot be is
no.
not the point. If it becomes, then what will be his remuneration?
as per this, his basic pension after deducting from his basic pay at the time of his retirement. That is why the second person, although his remuneration as per terms of contract, he was in a very lesser amount, but he is getting more because we are following same principle.
I am asking you a question for the third time. Assuming that his pension becomes 80,000 rupees from 1st of April, then what is the amount of contractual salary he will get for working under the Armed Force Tribunal?
By following this clause 6.
What will be the amount? 0 rupees. Is it not?
Clause
So you
6.
understand how absurd your officials are working. Take your seat, please. Heard Mr. Ayer, they will back. Learned Counsel.
And
explain
one
it.
more thing, Lordship, regarding that exceeding his power, this
We'll award him interest at the rate of
Lordship,
12%. per
kindly
annum.
Lordship, because he now he says that his terms has been extended till May, but this clause which this regulation which he is relying, Lordship, it also says that it cannot be beyond 70. In fact, it's
we are
beyond,
not
it's
concerned.
only up to 65, and after that he has to take prior approval. And but
We are
he is
not
doing it.
concerned with those things. We are only 12% per annum interest has to be paid, which will be recovered from the salary of the erring officials. This is one we are going to make. This is a complete non-application of mind. These people are sitting there, absurd ideas. You engage a person on a fixed remuneration of 80,000, and then some whatever weird rule you say that okay, 80,000 will be minus the pension you are getting. How are you concerned with the pension? Are you giving him full salary of a regular employee of PPS level? Then it is understandable. You say that, okay, full salary is 1,50,000 minus pension. Oh, you are engaging him in a contractual basis and then saying you will deduct the amount of pension. How can you do that? So this judgment will also say that this is an absurd clause. Complete non-application of mind. Somebody has not read it properly. You are doing all these things to just to harass people. And he's made a categorical statement that you're giving full remuneration to others.
That I have tried, but I have not received anything. But he had also not given anything in
All right,
proof,
all right.
Lordship.
That's all right.
That-
You've done your job. What is that? Anything more you want to argue?
That 65 is the actually he should be engaged up to 65 years as per this his
No, you are not filing a writ petition here. That's not the
Lordship.
plea.
and
He is only aggrieved because of this 14/8/2024.
my another submission is that the deduction or the impugn order which based on the notification, those are also not under challenge in this writ petition. Only the impugn order has been challenged, Lordship. The basis of this impugn order is the clause remuneration of the notification, as it is very clear that the last pay after deducting the basic pension from the last pay, that is what is done in the case of both the writ petitioners, Lordship. That is why the next one person is in fact earning more after the deduction also, Lordship, because his basic pension are.
Yes, yes. So the more the pension rises, the lesser amount of salary you will get.
Lordship.
That's what I'm saying. This is
Yes.
an absurd, weird logic. I'm shocked that the government of India officials are there who are working on this logic. You engage someone for 80,000 and say that if your pension goes up to 80,000, then you will get 0 rupees. Shocking. That is the reason we'll impose 12% interest on the amount.
The last clarification, that
Then it will go up to 18%.
no, Lordship, only one thing that
Yes.
as per our stand is that there should not be any contractual amount, but that was done. As after this,
There should
according,
not be any contractual amount.
amount has to be this contract period may be there, but amount has to be in consideration of the remuneration that is
So
in
what
the
is the
notification.
remuneration? What is the amount he should have got according to you? He should have worked free of cost.
No,
Then
that it is stated that after deducting a lordship, I am reading again it. A fixed monthly amount shall be admissible, arrived at by deducting the basic pension from the pay drawn at the time of retirement.
So then you give it, what will be the amount? Then you say that. What was the amount he was drawing at the time of retirement?
That is
the time of
very clear,
retirement,
46,340.
Yes, he was at the time of retirement.
46,340.
No. What was his pay?
That is his basic pay, 46,340.
What was the gross emolument he was drawing at the time of retirement?
It is lordship at 46,331.
That was the gross emolument.
It is as per the lordship.
Oh, that should be the basic. That can't be the gross emolument.
Gross is 53,000 something. Yes, I have an next one document.
Hmm.
Page 56. Page 56. And also I have given the pay matrix level. 56 and 57. $5,900.
All right. That's all. You want to say anything? But Mr. Yathwadi, what is the difference in the other case?
Other cases, differences, lordship, he retired from the Indian Army as Subedar, thereafter he joined here, and his remuneration was fixed at 48,000. That has been reduced to refixed at 35,300. All right.
A.R. Tawilda, learned counsel appearing for the rate petitioner, also heard Ms. B. Sharma, learned CGC appearing for the respondent numbers 1, 4, and 5. Stop. Ms. A. Gain, learned CGC, has appeared for the respondent numbers 2 and 3. Stop. The core controversy involved in this rate petition pertains to the decision of the authorities to reduce the amount of fixed pay earlier offered to the writ petitioner as per the terms and conditions of his contract. Full stop. The facts and circumstances, leading to the filing of this writ petition, briefly stated, may be noticed hereunder as follows. Full stop. The petitioner herein has retired from service from the post of Senior Private Secretary under the Guwahati High Court with on attaining the age of superannuation with effect from 28 to 2015. Full stop. At the time of his retirement, the basic pension of the petitioner was rupees 20,070 per month. Full stop. Immediately after his retirement, the petitioner had handled a few assignments. No, right like this. No, right like this. While serving in the Guwahati High Court, the petitioner went on deputation for a period of 3 years to the Armed Forces Tribunal as Principal Private Secretary, wherein he served in between 1/6/2011 to 31/5/2014. Stop. After retirement, the petitioner was re-employed as Principal Private Secretary on contract basis for a period of 4 years with effect from 5/6/2015 to 25/2/2019. Full stop. Full stop. In the month of February 2019, the petitioner had again submitted an application before the chairperson of Armed Forces Tribunal, New Delhi, for appointment as consultant, principal private secretary, close, in the Armed Forces Tribunal from a regional bench at Guwahati. After approval of the chairman of the tribunal, New Delhi, by engagement letter dated 11/3/2020, the petitioner was offered engagement as consultant PPS in the Armed Force Tribunal, regional bench at Guwahati for a period of 6 months on the at a fixed monthly remuneration of rupees 60,000. Stop. Accordingly, the petitioner joined as PPS in the Armed Forces Tribunal regional bench Guwahati on 13/3/2020 by accepting the terms and conditions of the contract of engagement as laid down in the letter dated 11/3/2020. Poster. While discharging his duties as PPS engaged on contract basis, the remuneration offered to the petitioner was enhanced to rupees 65,000 per month with effect from 1st February 2022. Full stop. Thereafter, the contractual remuneration of the petitioner was further enhanced to rupees 80,000 per month with effect from 1/5/2022, wide notification dated 01/06/2022. Stop. Accordingly, the petitioner had received an amount of rupees 80,000 per month as remuneration till the month of June 2000. Till the month of
June 2020. June 2020.
June 2024. However, on 14/8/2024, the respondent number, this is respondent number?
5.
The respondent number 5, that is the senior accounts officer, area accounts office, had issued a notification reducing the emoluments of the petitioner from rupees 80,000 per month to rupees 26,270 per month, allegedly on the ground that the remuneration fixed under the contract agreements was in conflict with the guidelines laid down wide office memorandum dated 9th December 2020 issued by the Government of India, Ministry of Finance, Department of Expenditure. By referring to the materials available on record, Mr. Tahvildar submits that his client was engaged on contract basis, which laid down clear terms and conditions of contract. As such, the respondents have acted arbitrarily in unilaterally reducing the remuneration of the petitioner without a valid basis. Full stop. It is also the submission of Mr. Tahvildar that save and accept the petitioner and another employee engaged on contract basis as consultant JAO under the Armed Forces Tribunal, Regional Bench Guwahati. All other similarly situated employees across the country are being permitted to draw the amount equivalent to that originally offered to the petitioner as per the contract agreement. Full stop. Therefore, submits Mr. Tahvildar, this is a clear act of arbitrary and discriminatory treatment meted out by the authorities to the petitioners. Full stop. Contending that the contractual service of his client is valid till 25/5/2025. Mr. Tahvildar has argued that until such time the contract expires, the authorities would be bound to pay the remuneration to the petitioner as per the terms and conditions of the contract. Full stop. Miss B. Sharma, Lanet CGC, appearing for the respond numbers 1, 4, and 5, on the other hand, has strongly argued that the remuneration offered to the petitioner under the contract agreement was not consistent with the guidelines laid down by notification dated so and so. What is it?
9/12/20.
9/12/2020. Moreover, the original contract, moreover, the remuneration offered to the petitioner under the terms and condition of the contract agreement was not done after obtaining prior approval of the, what is the department?
Principal Integrated Financial Advisor.
Principal Integrated Financial Advisor. However, as soon as the anomaly was detected, the remuneration of the petitioner was reduced.
Lordship, Annexer B is also there. We have sent letter to all the tribunals on 26/3/2024. The office.
Reduced to a sum of rupees 26,270. So as to make the total amount receivable by the petitioner as rupees 80,000 after deducting his pension. Miss A. Gayan, Lanet CGC, appearing for the respond numbers 2 and 3, has produced the relevant records to demonstrate that the approval of the finance officer under the establishment of, what is it, integrated financial?
Principal Integrated Financial Advisor.
Principal Integrated Financial Advisor was obtained by the Armed Forces Tribunal before issuing the engagement letter to the petitioner, and also before enhancing the remuneration to rupees 80,000. Full stop. I have perused the records so produced by Ms. Gayan. Full stop. Next paragraph. At the outset, it would be pertinent to note herein that while the petitioner was serving, it will be pertinent to note herein that the post of PPS in the Armed Forces Tribunal from a principal bench is treated to be equivalent to the post of Deputy Registrar. Full stop. As per the notification dated 1/6/2022, the Deputy Registrar or equivalent post is entitled to monthly remuneration of rupees 80,000. Full stop. As stated above, the petitioner was originally engaged on contract basis by letter dated 11/3/2020. Full stop. Thereafter, his remuneration was enhanced to rupees 65,000 per month with effect from 1/2/2020. By letter dated 1/6/2020, the remuneration payable to the petitioner was further increased to rupees 80,000. The terms and conditions of engagement of the writ petitioner on contractual basis are reproduced herein below for ready reference. Which page is the last terms and conditions?
No, so the last one is that page.
Terms and
Page 34.
engagement of the
Page 34.
petitioner as consultant issued on 23 June 2022 are reproduced herein below as for ready reference. Page 31, double tick to double tick. Next up. From a bare reading of the terms and conditions of appointment stroke engagement, it is clear that the petitioner was entitled to receive a consolidated and fixed remuneration of rupees 80,000. Such remuneration had no connection with the pension that he would be drawing due to his past services rendered under the Guwahati High Court. Full stop. Full stop. Not only that, it is the admitted position of fact that the petitioner had received the amount of rupees 60,000 and thereafter 65,000 and finally rupees 80,000 per month as remuneration for rendering his services. Full stop. There is nothing in the contract agreement which lays down any condition that the fixed remuneration will be adjusted against the pension that the petitioner is drawing for his previous services. Next paragraph. It is no doubt correct that in the guidelines laid down by OM dated 9/12/2020, there is a clause pertaining to remuneration, which is quoted herein below for ready reference, page 51 of the affidavit in opposition. A bare reading of the aforementioned clause does indicate that the amount payable to an employee is required to be deducted from the basic pension. However, the fact remains that no such indication was given in the engagement letter issued to the petitioner. Moreover, it is not understood as to how basic pension can be deducted from the fixed monthly amount payable to a contractual employee, since the engagement is purely governed by the terms and conditions of the contract. Not only that, the clause pertinent to remuneration, as noted herein above, prima facie appears to be mutually contradictory, inasmuch as it has further been mentioned that the amount of remuneration so fixed by the contract shall remain unchanged for the term of the contract. Be that as it may, the core issue which would arise for consideration of this court in the present proceeding is as to whether the petitioner has the right to receive the remuneration which forms the terms and conditions of the contract based on which he was engaged. The answer to the said question has to be an emphatic. Answer to the said question has to be emphatically in the affirmative. Full stop. Full stop. Once an employee is engaged on contract basis, all conditions of his service shall be governed strictly by the terms and conditions of the contract, and same cannot be altered unilaterally merely based on some interdepartmental guidelines such as the one contained in the OM dated 9/12/2020. Even if it is the fact that the engagement letter issued to the petitioner was contrary to the terms and conditions contrary to the guidelines applicable in this case, even then, the writ petitioner cannot be made to suffer for that. Full stop. It is a different matter that even under the terms and conditions of the guidelines, referred to by the respondents, it appears it is completely untenable to hold that the contract agreement did contain clauses which are contrary to the terms and conditions, which are contrary to the guidelines. Full stop. That moreover, as noted herein above, Ms. Gayan has produced the records to show that necessary approval from the concerned authorities was obtained by the Armed Forces Tribunal before issuing the engagement letter to the petitioner. If that be so, if the respondents cannot now be allowed to contend that the remuneration offered to the petitioner, which was in fact availed by him, was not in accordance with the guidelines applicable in this case. First of all. Moreover, Ms. Sharma has not been able to convincingly deny and dispute the fact that similar recourse had not been taken by the authorities in case of other contractual employees serving in the various armed forces tribunal benches who are drawing remuneration, remuneration not connected with, who are drawing fixed remuneration, dehors the basic pension drawn by them. Full stop. For the reasons stated herein above, this court is of the opinion that the writ petition must succeed and the same is hereby allowed. The impugn order dated 14/8/2024, who are the writ petitioner, is hereby set aside. Consequently, the petitioner is held to be entitled to receive a sum of rupees 80,000 as fixed monthly remuneration for the period of his contractual service. Full stop. The arrear dues payable with effect from the month of June 2024, July 2024 till today shall be paid to him within 1 month from today. Full stop. Since the petitioner has been unduly made to suffer for no fault of his own, and he has been denied the benefits which was available to him under the contract agreement, the arrear amount as payable to him shall carry interest at the rate of 12% per annum from the date on which the amount had become due till release of the same. Full stop. For the current period, petitioner shall continue to receive, petitioner shall be continued to pay a sum of rupees 80,000 as fixed remuneration till the period of validity of the contract agreement. With the above observation, the writ petition stands allowed. In the other matter, we'll make the change. You give a short note to him, we'll make the changes.
Already noticed.
Yeah, another matter, there is a little background is changed.
Lordship,
The
during the pendency of the writ petition, another contract was made in the month of January, although there was no stay petition, but for that period.
The contract was renewed from time to time.
Yes, Lordship.
Contractual amount has to be paid. What was the amount in that? 26,000?
No.
80,000. You pay, the contract was renewed from time to time. That will add that line. See, the point is you can't do it like that. We'll not allow it. That's the end of the matter. You engage someone on contract, you say that we'll pay you 80,000, you will have to pay him 80,000. You will have to, that's the law.
That author, respondent 1, 4, and 5 may have a discuss of 2, 3 had, because he had exceeded, that is our stand. If there is, if he had exceeded that.
You do whatever you think is right. You cannot penalize him for that. You have to pay it.
Some observation to that, Lordship, if he had.
You do it on your own. We'll not go into it. He has come by saying that you engaged me on contract basis, telling me the salary. You have suddenly stopped it. We have answered that. He has asked for relief. We have granted him relief. You do whatever you want to do internally. We can't say anything on that. That you can do. Yes. Next matter. So 2 writ petitions stands disposed of. Separate order.
Please, your lordship. Lordship, on the last occasion, let us filed a counter affidavit. That affidavit has not been filed by the respondent yet. They have to explain one factor regarding the who is original inhabitant. Because if your Lordship remember, the petitioner has been excluded from joining service. He has secured 35th rank in the SCS service. She has not been allowed to join on the basis that they claim that the petitioner is not an original inhabitant. She is married to a person from Assam and residing here for last 13 years. So her contention is that she consider herself to be original inhabitant because as of now, the government has not come up with any answer how the criteria will be
So,
determined.
you argue your case, we'll decide it.
My lord.
Lordship, kindly see
This
Lordship,
way, that way, we have to decide it.
Yes, my lord.
This matter
104.
was fixed today.
Yes, my
Yes, 104 Lordship, kindly see page number 104 Lordship.
No, let him argue. You give
Lordship,
your-
Lordship, I have some instruction, Lordship. Kindly see
No,
the eligible criteria, Lordship.
No, you have not filed affidavit.
No, I will file, Lordship. I
You
will
will
file.
not get a chance to file.
No,
These
I
are
will file.
matters which cannot be adjourned again and again and again.
Lordship, so far communication was made,
That
Lordship.
is why people are losing faith on the
No,
court system.
communication was made, Lordship.
Hmm.
The communication was made to the skill development.
Mr.
skill-
Goswami, you make
Lordship.
your argument, let him argue, you make your argument, we'll pass our
Lordship,
judgment.
I will file the affidavit, Lordship.
Why
will
did
file
you
the-
file it earlier?
No, Lordship, I will, because Lordship, some instruction is yet to be received, Lordship. And
That-
communication
that
is
we
there,
can't
Lordship.
help
The personnel department B, Lordship, it referred in his letter, in their letter, Lordship, to
No,
the
no, Mr. Goswami, on 5/3/2025,
Lordship.
you prayed for time to file
Lordship.
affidavit, the time was given.
More time is required, Lordship. Some instruction is
Then
yet to
you
be.
appoint her provisionally.
No,
We'll give
Lordship,
you six months
Lordship,
time.
Lordship, kindly.
Provisional appointment.
Last,
you have to make.
last,
You
Lordship.
can't delay it and then take advantage of that.
No, Lordship, Lordship, kindly see the letter, Lordship. That is, some instruction is sought from the skill employment exchange
That is
department,
your,
Lordship.
that is your problem. We
Lordship.
can't help it.
Kindly fix the matter after behave vacation, Lordship. I will, during this period, I will submit my affidavit, Lordship.
No, at every case, this is what you're saying.
No, Lordship, kindly, this is a serious matter, Lordship. It is,
Serious or non-serious, let us decide.
Lordship,
You are not supposed to decide that.
Lordship.
You file your affidavit, argue your
Lordship,
case.
I will file,
The
Lordship.
court is ready to hear and give judgment. You are preventing. The
No,
people
Lordship.
are thinking the
Lo-
judges are not working.
Lordship, so far what happened, Lordship, some communication is going on, Lordship. One instruction.
Yes, what do
is
you have
sought
to say?
My lord, otherwise it has been almost 3-4 times they have been
We'll
taking.
give him one more chance and if he doesn't file, we'll make it clear that their right to file affidavit will be struck off.
That may be recorded. My lord.
Yes.
Kindly, please.
Heard Mr. K. Chaudhary, learned counsel appearing for the writ petitioner. Also heard Mr. J. K. Goswami, learned additional senior government advocate Assam appearing for the respondent who prays for one more opportunity to file affidavit. The prayer has been opposed by Mr. Chaudhary by contending that the respondents have already availed enough opportunities to file affidavit. Further delay in disposal of the writ petition is causing serious prejudice to the interest of his client. Be that as it may, considering the nature of issue involved in this writ petition and the request made by Mr. J. K. Goswami, one last chance is granted to the respondents to file affidavit. The registry to list this matter again on
Lordship, first week of May, Lordship, within April, I will file.
on 5th of May.
First May,
Like this, you say, accordingly,
first May if possible.
time is granted to the respondents to file counter affidavit on or before 25th of April by serving advance copy upon the petitioner's counsel. It is made clear that the petitioner's counsel, the petitioner may thereafter file rejoinder if so advised. Registry to list this case again on 6/5/2025 as a fixed item.
May I request, my lord, 8th of May.
8/5/2025 as a fixed item. It is made clear that if the respondents fail to file counter affidavit on or before 25th of April 2025, their right to file affidavit in this case shall stand struck off. The matter will thereafter be decided based on materials already available on the court.
Highly obliged. Obliged.
May I please?
May I plead your lordship? Lordship, my senior has some difficulty today, lordship. Lordship, may I pray to take up this matter on Monday?
Yes,
But the subject matter here is that the petitioner is serving as the senior most professor in the homeopathic medical college.
Hmm.
And the respondent, instead of promoting him to the post of vice
so
principal,
counter affidavit has been filed.
affidavit has been filed, we have filed reply also, that is on record.
And lordship, we have received your reply. Actually, I also need some instruction regarding this reply.
When did you file reply?
On 1st of April, in the forenoon, I have served her copy. Madam.
Okay, then
Monday.
Tuesday we'll take it up.
No,
Next,
lordship, Tuesday, not Monday, lordship. On Tuesday, my senior will be out of session Monday.
then it will go to some other bench because your senior's convenience is fine, but the court's convenience also matters.
The only thing is that, my lord, the department is now going for another DPC of the readers, for person number 4 is also there.
Thursday.
Thursday, with an assurance that no further adjournment will be paid.
My lord.
Mr. K. M. Haloi and Ms. R. Kakati, learned counsel for the respondent number 4, submits that pleadings have been exchanged in this case and the matter is ready for final disposal. However, learned counsel for the respondent number 4 prays for posting this matter again on 10th of April 2024 for admission hearing as a fixed item with an assurance to this court that no further prayer for adjournment will be made on behalf of her client on the next date fixed. Mr. D. Upamanu, learned standing counsel for the Health Department Assam, is present and does not have any objection to the said prayer. In view of the above and as requested by learned counsel for all the parties, register to list this matter again on 10th of April 2025 as a fixed item in the top of the list for admission hearing.
Much.
Lordship, I am paying for accommodation for today, your lordship, and sorry, lordship, yesterday we could not serve our adjournment request because we are in a dicey situation, lordship.
Sorry?
In a dicey situation, lordship, whether we are able to prepare the case or not.
Dicey situation.
Lordship, my senior actually reached yesterday late, lordship. That's why,
So
lordship.
what is this matter? This will go after vacation next
Yes,
week.
lordship, as per the confidence of the
On the prayer of learned counsel for the writ petitioner made with the consent of the opposite parties, let this matter be listed again in the 4th week of April or
Lordship, can it be on 24th of April, Lordship?
24th of April 2025 as fixed items.
Lordship,
Highly.
there is an ad interim order, your lordship, that may be continued. Ad interim order is there.
The interim order, if any, shall continue till the next.
Much.
Highly, Lord.
I have 20.
Yes.
My lord will see the order, last order, my lord, on 25th March, my lord, lordship has directed.
Lord, even I presume that this will require an affidavit, however, it has not been filed. If your lordship allows me to place the instruction, I'll just place that. Lord. There's something,
Who is appearing for the department?
Name has been shown.
he was here, Lord, he's. he has
At
gone-
least, my
he has
lord, my
gone- yes.
arrear salary, my lord, be given to me, my lord.
1 minute. Yeah, Mr. Goswami, you are appearing.
Instruction received, Lordship. So far, in this instruction, Lordship, the department has already intimated the principal accountant general, Assam, regarding the final GPF withdrawal application of the petitioner. Via departmental letter number so and so 8/7/2024. GPF, regarding GPF is sent, Lordship. In other matters, Lordship, I received a parawise comment, Lordship.
What is the amount in GPF?
Last page, annexure. Page 25.
That we have received.
That you have received?
Yes.
You have received?
That a long back, my lord.
No. It is on
See, page 55.
The amount
24.
67,713.
Only that much you have received, my lord, nothing beyond that.
No. What I am asking is, what is the amount now? What are the pensionary dues you are now entitled to receive?
My lord, my salary from my lord, area salary. Possible see from my prayer portion, my lord. Earlier salary, my lord. Earlier salary from 2027-8, 2009 to 14-4, 2023 as a SCF. Thereafter, my lord, from 9-10-14 to
So when did the petitioner retire?
retired February, my lord. February, 29 February 24.
20?
Oh.
You are not sure about it.
Yes, here.
He
24.
retired about 1 year back.
My lord.
He is not getting provisional pension also.
Nothing, my lord, no provisional, nothing. And I'm cancer patient, my lord. I want at least my salary, area salary, be given so that I can go for treatment.
So why you are not paying him?
Lordship, departmental proceeding as well as the criminal proceedings pending, Lordship.
But is there any order to stop his pension?
No, Lordship.
So for area salary, my lord, they cannot stop.
Yes, we are giving personal appearance of the secretary. You are not coming up with convincing answers.
No, Lordship, I have the instruction is here, Lordship.
Instruction may be there,
Lordship,
but let the secretary come.
Lordship,
Yes, he will now come.
no, Lordship, there is no specific order, Lordship, for stop the.
Yes. Take down. Heard Mr. J. Bodhi and
Lordship,
personal
Lordship,
appearance.
Lordship,
Yes.
Lordship,
Person
Lordship,
is fighting cancer.
Lordship,
You
all
don't
the,
have any answer despite repeated requests.
no, Lordship,
What do you think we are doing here?
Lordship,
What do you think the judges are doing here?
no, Lordship,
You have been given time, you don't have any
apologize.
answer, why you are not releasing his pension?
I apologize, Lordship, but
No,
so far the
he has
instruction,
to come.
Lordship, so far the instruction, Lordship, it appears that the departmental proceeding as well as the criminal proceedings
Is
pending.
there any order stopping
No,
his pension?
No.
Can you stop it? Yes. Heard Mr. J. I. Borbe and learned counsel for the lead petitioner. Also heard Mr. J. K. Goswami, learned additional senior government advocate also appearing for the state. Mr. D. Bhattacharya, learned standing counsel for AG ANE Assam, is present on behalf of the respondent number 5. The state will be 1 to 4. The lead petitioner hearing. Retired from service on attaining the age of superannuation with effect from 1st March 2024.
My lord, I retired on 29 February 24.
That's called 1st March
My-
2024. In the post of Deputy Conservator of Forest.
My-
Is it?
My lord.
Full stop. Since then, Forest. The petitioner is entitled to receive pension under the rules. However, his pensions have been withheld apparently on the ground of pendency of some departmental and criminal proceeding. Full stop. The grievance of the case of the petitioner is that save and accept releasing the gratuity amount due and payable to him, the authorities have not paid any other pensionary dues, including area salary payable to him from the month of 27/8/2009 to 14/4/2023. Full stop. On the request of learned government advocate, next to right. The petitioner has further urged that he is a cancer patient and is required to go for advanced treatment.
Cancer and open heart surgery.
He's a cancer patient who is also facing the prospect of undergoing an open heart surgery. Therefore, the petitioner is in dire need of money, without which he cannot avail the requisite medical treatment in advanced medical treatment. Full stop. On such ground, Mr. Borbuya had submitted that at least some amount pertaining to the area salary payable to the petitioner be released so as to enable him to avail the medical treatment. Full stop. On a pointed query made by this court, Mr. Goswami could not give any convincing answer as to why his pension has been withheld. The learned additional senior government advocate has, however, admitted that there is no order by any statutory authority for stopping the pension of the petitioner till date. First step. The learned government advocate was granted several opportunities to obtain instruction and file affidavit. Notwithstanding the same, there is no clarity in this matter as to why the department is not releasing the pension or at least the arrear salary due and payable to the petitioner under the law. First up, under the circumstances, this court is left with no other option but to direct personal appearance of the secretary to the government of Assam Environment and Forest Department, as well as the Principal Chief Conservator of Forest, to remain personally present on the next date fixed for answering the queries of the court. Full stop. List this case again on 13th of May 2025. Full stop. It is, however, made clear that if the department releases the arrear salary payable to the petitioners during the period from 27/8/2009 to 14/4/2023, without prejudice to the right of the department to proceed further in the matter, then in that event, the personal appearance of the two officials would not be required on the next date fixed. List this matter again on 13/5/2025. Registry to a copy of this order be handed over to Mr. Goswami. The registry to also communicate the order to the concerned officials so as to enable them to remain present before the court on the next date fixed.
Salary of two specs, my lord. Salary of two specs, my lord, up to 29/2.
Don't give the date, arrear salary due and payable to him under the law.
Lords.
If they release the arrear salary, the amount he
Must
receives,
oblige, Lords.
they need not come.
I must
Otherwise, they will have to come and we'll take turn at it.
Lords.
He will survive or not, my lord, I cannot. say.
Sorry,
He will survive or not this time, my lord.
that
Very-
we can't help. We can't
Very badly needed, my.
I
help.
will.
They will do it. Tell
Yes.
them to release it within next 1 week.
Lords.
If the things, if something happens and all this, and then the courts will look at it from a very, very serious angle.
Lords.
You can't stop these things unless there is an order. You can't. Yes. Order.
May it please your lordship. My lord, the order of this court is of 28/7/2023. I retired from my service on 31st of March 2023. And the order has to be complied even after service from 31/10/2023. The affidavit has been filed by the government in this case by the condemner respondent number 1. But my lord, the respondent number 6, on one pretext or another, delaying the matter, my lord. There are two orders of this honorable court. Sometimes they say that my original admit card is required, other documents are required, they summon me. Then after my retirement, my lord, they initiated proceedings against me. That also your lordship stays it. But my retirement benefit, not a single penny has been paid till date.
My lords, there's a special vigilance case, my lords. The vigilance case, they have, my lord, they have taken away every original document pertaining to petitioner, my lord, scrutiny, my lords. My lord, I'm giving it. Otherwise, my lord, we are processing is, assuming his date of 60 to be correct, we are processing is in the provisional pension, my lords. when in a way of processing, my lords, we found out that these documents were taken away by the SP vigilance, my lords.
But
Original, my lords.
all these facts were known to them.
One by one, you have to say.
Yes, ma'am.
Please take your seat, let it.
And my lords, regarding
What is
repetition,
the, where is the direction of the court?
Yes, my lord. Direction of this honorable court is at page 12. And 11 portion is at page 14. Then the consequential order in response to this order that the department has passed is at page 21. This was an order.
So why are you not released?
my lord, then my lord, in contempt, we file affidavit. We sought his documents, my lord. He said he lost all his documents. He filed a police FIR, my lord.
No, no, according to your record, there is a date of retirement of this person.
My lord,
What is that date?
my lord, according to us, it's 65.
All right. So court says that you go by your record,
My lords,
right?
my lords,
So you, according to your record, you are now to settle his pension.
my lords.
He's a
My
pensionable.
lord, will settle.
Why haven't you done it?
My lord, we to process my lord pensions, we need the original documents, my lord. That has
What
been-
original document you need?
My lord, his service book, my lords, his
Hmm.
everything, my lord, that has been taken away by the police. But my lord, in the meantime, my lord, we are processing his provisional pension, my lord. This is the.
No, where is the affidavit which says that his service book has been taken away by the police?
But this has come to a new, this has freshly come to our knowledge, my lords.
Well, that will be again a misstatement because your lordship will see the first the consequential order it passed in response to your lordship's order at page 21.
So that will differ, my lord. We have received a paragraph.
Just page 21, your lordship will see the consequential order passed after your lordship's order. This order was challenged in WPC number 7350 at
Which page?
page 21. They shot, your lordship will see, also read with, after your lordship's order, all these documents were in possession of the concerned department. This order sought to penalize me. I put this challenge before this honorable court in WPC number 7350 of 2023. That order your lordship will find at page 40. The page 21 order has been stated by this honorable court at page 40.
Page 40 of?
40 in the serial pages, my lord, nowadays it is marked. Page 40. Additional affidavit. And page 42 is the operative portion. Your lordship has stated the order at page 21. Now, your lordship will look into the affidavit filed by the contemners at page 43. Now you'll also see the affidavit filed by the contemners at page 43. By the respondent number 1, my lord. Page 43. Now your lordship will look at the date of filing is 28/11/2024. And in this affidavit, my lord, this ground is not there. Whereas, my lord, now they say the documents was taken by SP Vigilant on 13/6/2024. That is prior to filing of this affidavit.
No, first of all, this affidavit is filed in the contempt case.
Yes, my lord.
Who is the respondent number 1 here?
My lord, it's
Just-
R.S. Prasad, my lord, he is retired.
No, we have subsequently implemented the new one. The concerned respondent is now respondent number 6.
Almost original, everybody has retired, my lords.
Yes, so we have implemented new one is now at respondent number 6, Raspal Singh.
No, my lord, he has also retired. Rajpal Singh also retired. Now, my lord, we are processing his claim. And
You
we're
tell
going-
us who is to be summoned to the court. Tell us that. You have to, you can't do all this.
Videkshana
You see, you can't play around with person's pension and retirement dues.
No, my lords, we are not playing. We are
No,
just.
what else is
my
this
lord,
then?
what had happened, my lord, claiming first he did not say 65 is date of 62.
Oh, Mr. Gogoi,
My lords,
you go by what you
No,
think
sir,
is
sir.
right.
my lords,
That the court has already clarified.
my lords.
Your contention is correct, that he is not 65, he is this, whatever it is.
My lords.
After that, why are you not releasing his pension?
No, my lords, we are in the process of releasing, my lords. We are in the process, my lords. We have
No.
given them advice that you consider 62 as life. My lord will give me some time. It's in the process. We are process, my lord.
I think you have well enough time.
My lord, this
No, my lords.
Officers are taking the court proceedings very, very lightly.
No, my lords. Lordship,
We don't allow that, and we
my lord
know how to
will
handle
give
it.
us one more chance, my lords. We are proceeding with this, my lords, because there was confusion, my lords. Because, my lords, what will happen if we go by 62, then we have to deduct his all service benefits till 65. This is going on. Now he says we cannot do that because Rafiq Masi comes into play. So we have cleared every confusion. We have advised them to, by authorities to clear the pension from 62 only. Because he got 2 promotions also on based on 65. Gradation list was also published, my lord. He didn't object to it. But these things are now coming up, my lords.
So you file an affidavit.
Yes, my lords. We'll file and in the meantime, my lord, we'll process.
You file it by Monday, showing us what steps you have taken to comply with the court's
Monday,
order.
my lords, Monday.
Or we
Mon-
can
Mon-
give you time till Tuesday at the most.
My lords,
What steps have been taken to comply with the court's order?
my lords,
Then we'll decide whom we should call
my lords,
personally with the records.
my lords.
Heard Mr. B.D. Kaur and a senior counsel appearing for the petitioner who submits that despite repeated opportunities granted by this court, the order of the court has not been complied with till date. Mr. D. Gogoi and a counsel appearing for the respondents.
My lords, in my lords, issuing directly in contempt, my lords.
Take it as well. That is 5 and 6% of Under Secretary Selection of Support.
No, very good.
Very good.
Yes, sir.
Respondents submit that all necessary steps for compliance with the court's order has already been initiated. And
Well, it has to be by post.
Huh?
If lordship is passing orders in the repetition, my lord, it has to be by post.
no, are you appearing for the contemners here?
Contempt, my lords, my lord, nobody is now in the office. The original contemners, my lords. Nobody is in the office.
Then you have to implead them.
No, we'll implement them, but this is also.
But without implementing, my lord, how can I appear and file an affidavit, my
Look
lord?
at the order dated 4/10/2024 in the contempt case.
So who are the concerned persons now in office?
My lord, names have to be taken. One is Joint Secretary, my lords. Sachin
No,
Das.
give the name of the person who.
Yes, Sachin Das, my lord, Joint Secretary. my lords.
We can implement by filing the petition in the second.
Then he has to implement me first, then I can come, my
This is
lord.
the information new to me.
Mr. D. Gogoi, Lanet, so it will be both in contempt and writ. Departmental counsel submits that steps have been already initiated to comply with the court's order and release the provisional pension of the petitioner. First up, he prays for some time to bring those facts on record. On the request of Mr. Gogoi, Lanet Standing Counsel, Forest Department, Assam, time is granted till, we'll give you time till we'll have it on 10th then, 10th,
Yes.
10th of April 2025.
But your lordship has already indicated in the earlier order of court.
File an updated affidavit. File an affidavit bringing on record the steps taken by the departmental authorities till date to release the provisional pension of the petitioner. First up. In the meantime, Mr. Kaur, in the meantime, the petitioner in the contempt case may take steps for
We'll do it by Monday.
including the present incumbents in the office who are responsible for compliance of the court's order. Mr. R.K. Talakdar, and standing counsel for AGAME is present on behalf of the, yeah, on behalf of the, on behalf of the AG.
Yeah.
Here, the affidavits from the respondents are awaited. One affidavit was received in item number WPC 5561, item number 7. I'll file and reply to that. Otherwise, madam, the affidavits from the other respondents are awaited.
They have lordship send it to register post to me lordship. Today itself lordship, they have sent it. So I will file it. Otherwise lordship, the interconnected matter is lordship will be listed on 8th lordship.
Yes.
So my lord may take with this matter, then it will be lordship.
What is the interconnected matter?
505424 lordship.
5054.
WPC
5054.
505424 lordship.
5054 of 2020,
24.
that is fixed on 8.
8. So lordship may take with this matter. In the meantime, I will also file affidavit.
Learned counsel for the parties appearing in these cases have submitted that some more time is required to complete pleadings. As such, on the joint request of counsel for both the sides, let these matters be listed again. In the first week of May 2025, along with WPC number 5054 of 2024.
It is just fixed on 8 lordship. 5054.
Yes, that will be listed. This will not be fixed on, what will you do on 8?
It was tagged with another
Acha.
repetition as a part of
So let this matter be listed again on 8/4/2025 along with WPC number 5054 of 2025.
And the interims continue.
Interim order passed earlier to continue.
Obliged.
Item 22.
21. 22 is over. 7, 8 and 22.
7, 8, 20.
May it please, your lordship.
Yes.
Lordship, I am paying for an accommodation to the lordship.
You are playing for?
An accommodation, lordship.
All
And
right.
the agenda matter for the day, lordship.
It is for orders. What order is required?
Lordship, on the last occasion, one judgment was to be placed before your lordship. This similar matters were decided by the apex court, lordship. The judgment could not be placed.
Yes. Any objection? Mr. Your name, please?
B. Hazarika on behalf
Mr.
of
B. Hazarika, learned counsel appearing for the petitioner, is for posting this matter again after 3 weeks, so as to enable him to obtain updated instruction. The learned counsel for the respondent is present. Respondents Union of India is present and does not have any objection if the prayer is allowed. In view of the above, let the matter be listed in the first week of May 2025.
Obliged.
For hearing.
No.
Please, your lordship. Your lordship, this matter is covered by number of cases judgment passed by this honorable court. And we have already submitted those judgment also before your lordship. And my prayer is also very limited here. Similarly, what disposed of by this court in other cases. So here it is a case of that petitioner was recruited as in Assam Rifle as GD, and then after his recruitment, he was discharged with on the ground of medical unfitness. Then medical board came to court. Court passed order for establishment of medical board. Medical board was established, and then he was found fit. Then again he was allowed to. He was appointed again here. Here the only claim is, your lordship, he was joined in the year 2001. Synopsis बनाना चाहिए। He was provisionally appointed on 28/5/15, your lordship. But now we have been treated as a appointee from 28/5/15, and our claim is that from initial appointment, that is, it was on 23/5/2001 when I was appointed. From that date, and the honorable court has passed order in that way. Your lordship may kindly
Yes, order in which case? What is the name of the party?
Your lordship, there is WPC 7201
Hmm.
2018. Then WPC 8803, 2018. There are many more, but I have done this too, like similar order. And your lordship, for this case of this 7201, 2018 is similar to my case. Only the date of appointment thereafter, when he was medical found fit, it is 2015, because I was held up on the ground of overage. But when again I came a second round of litigation by filing WPC, then appeal was filed and court allowed that this ground is not maintainable, and the court allowed my appeal and writ. So on from that date, I joined here again. So this is the, your lordship, it is.
Yes, this is covered by.
My lord, it is distinguishable in facts, my lord, paragraph 13 of the judgment which has been pointed out.
Then we'll hear it.
My lord.
Second, at 2.
Yes, your lordship.
Same नहीं है आपका discharge order set aside नहीं उन केसेस में discharge order set aside हो गया
हाँ, हमको अपॉइंटमेंट कैसे दिया?
इस केस में discharge order set aside
नहीं सर, नहीं पता हमको अपॉइंटमेंट लेटर है मेरा।
हाँ वही लेटर है वो subsequently आपने ट्रेनिंग किया ना
हाँ, तो उसमें जब हमको मिलेगा तभी तो करेगा ट्रेनिंग। So you make me some submission, but it is same, similar, exactly. खाली है, I was over होने के कारण हमारे।
Yes.
My lord, the cases which have been relied upon, my lord, stating that those are similar.
Just a minute, let me
Yes, my lord.
just have a look at the fact.
My lord.
So in the synopsis, you have given initial date once as 23/5/2001 and once as 25/3/2001, which is correct?
Yes, your lordship.
Both are correct.
23/5/2001, date of appointment.
And then next page you have written 25/3/2001.
Lordship. No, it should be your lordship, that is Mr. 23/5/2001, it should be.
And which judgment covers your case?
Your lordship, that is a Prabhu Dayal's case, that is a WPC number 7201, 2018, because the recruitment was the same year. Date of appointment, discharge same. Only one date will differ, that is the reappointment, because he was in one only difference is that he was overage, he was found, and then the division bench considered that no overage will not come, will come here, and he was allowed. and thereafter he was reinstated. So that date is different, otherwise everything is same. And it is covered by one case of this court, is the Santlal, the review petition. On the basis of that, all these judgments were passed.
So why it is not covered? Why his case is not covered under this? What is the distinguishing
The
fact?
petitioner was a recruitee, my lord.
Hmm.
And those two cases, my lord, they were not recruitees. No, they were enrolled and they have undergone training. My lord, will take paragraph 13.
No, the 23/5/2001 applies for all of them. Even the petitioner in this case,
Petitioner was.
Prabhu Dayal, he was also, his intake was also 23.
No, my lord, if my lord will take paragraph 13
Yes.
of the judgment, it says, my lord, it is not in dispute that the petitioner has undergone the recruitment process in its full rigor and was accordingly appointed on 23/5/21. The requirement of basic training was also been undertaken by the petitioner. Here, he has not gone to basic training. Here, my lord, after
The question is not that. Question is whether his initial appointment should be treated as 23/5/2001 or a subsequent
it
date.
cannot be, my lord, because as per.
All right, you file an appeal. We can't.
My lord,
appeal.
after-
This is wastage of time. When
Lord-
everything is same, have you preferred any appeal against this order?
No, the facts are different, my
All right,
lord.
third Ms. K. Yadav, Learned
No,
Counsel
it
for-
is the date of enrollment.
No, I will record it and I will reject it. You are just wasting the court's time, Mr.
My lord,
Gupta.
I have not submitted, my lord, my submission may be recorded, but I will quote few rules
We'll record your submission that this is distinguishable on facts.
and also, yes.
And I'll reject that. You have to file an appeal. These are similar orders. The court has to pass similar orders.
My lord,
Because the
because-
key issue is, contrary to your understanding,
My
key
lord-
issue is not whether he had undergone training or not.
my lord,
Key issue is here also, in that case also, they were
no,
discharged.
they
and-
were not recruitees, my lord. The petitioner is a recruitee. In case of a recruitee, my lord, the date of appointment will be from the date of enrollment. It is from the process of recruitment is as such, my lord, that
No, what is
initial
it by recruiting?
recruitee, my lord,
Here in this
Ma-
Prabhu Dayal case,
provisional selected. Recruitee, my
Prabhu
lord, means-
Dayal's case, he did not participate in the selection process.
he,
Court
he, my
order
lord,
clearly says that
paragraph 13, my lord, his discharge order was also set aside. Here,
Mr. Gupta, you are now just. His order
Paragraph 13.
clearly said that the petitioner had undergone the recruitment process
and
in its
basic,
full rigor and accordingly appointed on 23/5/2001.
thereafter,
You are saying he is not a recruitee?
no, further, my lord, if my lord will take the further next line, my lord, the requirement of basic training was also been undertaken and in the midway.
Hmm.
So, my lord, the moment a person qualifies the medical examination after being a recruitee, he is deemed to be enrolled and then he undergoes a training process, my lord. And it is during that training process, he was medically, my lord, held to be disqualified. Here, petitioner was not enrolled in the service. After being provisionally selected, my lord, the appointment letter clearly says that the appointment is provisional and subject to further medical examination. That medical examination he failed. So he was not at all enrolled in
Then
the.
why have you reinstated him? You have not
Reinsta-
reinstated him.
No, it is
You have
not a
not reinstated-
reinstatement, my lord.
You have not, this petitioner in this petition, he is not back in service.
He is back in service from the date of, my lord, enrollment, that is 2015. Now, what the petitioner is claiming, my lord, that his date of joining should be taken from 2001.
Hmm.
Which cannot be, my lord, because it is from the date of enrollment that the date of joining has to be counted. And the petitioner were simply the recruitee. Their selection, after the qualifying the, my lord, written examination, they were subject to medical examination, which they failed. In other two cases, my lord, the petitioners qualified the medical examination and they started to undergo for training also. So at that stage, my lord, they are at the stage of a, my lord, they were enrolled. After enrollment, my lord, there is a process called attestation, and then, my lord, the appointment is confirmed. My lord, if I may just point out the rules, my lord. You know.
Yes.
Lord, this is rule 15 of the, my lord, Assam Rifle Rules 2010, which deals with procedure for enrollment, mode of enrollment, and other matters connected therewith. Now it says before a person is enrolled as a member of the force, the commandant of a unit and any other officer who may be appointed as an enrolling officer by the Director General shall read and explain to him, cause to be read and explained to him in his presence, the conditions of service to the post to which he is to be enrolled, and shall put him the questions contained in the form of enrollment as set out in the appendix 1, and shall, after having cautioned him that if he makes a false answer to any question, he shall be liable for punishment under the act, record or cause to be recorded his answer to each question. If after complying with the provisions of sub-rule 1 and such other directions as may be issued in this behalf with the Director General from time to time, the enrolling officer is satisfied that the person desirous of being enrolled fully understands the question put to him and consents to the conditions of service. And if the said officer is satisfied that there is no impediment, he shall sign and shall also cause such person to sign enrollment form, and such person shall thereupon be deemed to be enrolled. Those two cases, they were enrolled, my lord. The petitioner was not enrolled. Petitioner was simply a recruitee, and my lord, he failed to qualify the medical test in the year 2001. Subsequently, pursuant to the order by this honorable court, my lord, a review, he was allowed to undergo, my lord, fresh medical examination, to which he qualified after, my lord, 14 years. And in that circumstances, we have, after being successfully qualified, he was enrolled.
Have you prepared any appeal against this judgment?
No, no, my lord.
To complete your argument.
My lord.
You may be right,
No.
but this judgment you have not appealed. That's the point. So you conclude and then I'll dictate the judgment.
And my lord, sub-rule 3 says, my lord, every person enrolled as a member of the force shall be administered on oath and affirmation in the form set out in appendix 1. And so, my lord, in this case, my lord, the petitioner, in the year 2001, no process of enrollment was carried out, nor there was any attestation. My lord, he was, my lord, simply medically, my lord, due to medical reasons, he was removed from the service. my lord, one paragraph I would just like to take, my lord, to paragraph 13 of my affidavit, my lord. Affidavit in opposition. That it is stated that in compliance to the order,
Yes.
the petitioner was appointed with effect from 25 June 2015, being the date of reporting to the ARTC and subject to fulfillment of the laid down eligibility criteria in the provisional appointment letter dated 28 May 2015. After a gap of 14 years, on the strength of the court order dated 26/10/2014, the petitioner was called afresh for basic military training after his re-medical examination. Wide provisional appointment letter dated 25/5/2015. He reported to the Assam Rifle Center on 25/6/15 and accordingly underwent basic military training in 2016. The petitioner took oath and affirmation on 24/10/2016, and thereafter he was posted to Unit 43 Assam Rifle for performing duties. The petitioner has been rightly been appointed with effect from 25/6/15 in the Assam Rifles from the date he reported to the Assam Rifle Training Center for training afresh. The case of the petitioner and the judgments which have been relied upon are, my lord, on the factual facts, my lord, are slightly different. They were recruitees, my lord. And these petitions.
So why are you repeating
My
again?
lord.
Beyond that, do you
My
have
lord.
anything to say?
And my lord, if I may take my lord to the my lord, initially page 23 of the writ petition, my lord. When the petitioner initially came before the honorable court, my lord, page 23. The direction, my lord, it's third paragraph, my lord. Page 23.
Yes.
Only direction initially, which was given by the single judge, my lord, was that in view of the submissions made by the learned counsel for the respondents, irrespective of the earlier medical incapacity during this long period of time, since the discharge of the petitioner way back in 1991, my lord, this should be 2001, my lord, is a mistake, my lord. The petitioners might have been unfit for engagement in Assam Rifles. It is provided that while considering the case of the petitioners in respect of the medical incapacity in reference to the earlier finding of the medical board, it would also be open for the respondents to consider that aspect of the matter while taking a decision in this regard. Now, my lord, pursuant to this, my lord, next page.
Yes.
The authorities, my lord, wide in compliance with the order, has called the petitioner for a medical board examination, my lord. This is the notice, my lord, that you have to appear before the medical board. And my lord, next page 25.
Yes.
Is the medical board examination findings, my lord, wherein the authorities have rejected the case of the petitioner on the ground that he became overage by the time, my lord, the medical board was to be called for. This order was, my lord, challenged before the single judge again, my lord, and subsequently, my lord, at page 26. Challenge to this order was negated, my lord. This order has not been annexed by the petitioners. And my lord, thereafter an appeal was preferred and the direction of the honorable court is at, my lord, page 31. The division bench allowed the petitioner to, the overage aspect was directed to be ignored, my lord, and the department was asked to allow the petitioner to be taken back into service on re-medical examination.
This petitioner.
Yes,
The name of the petitioner here is
my lord, here the writ
Naresh
petition.
Kumar, and in this case it is.
Yes, my lord, series of writ petition were there.
Then
If
why
I
are you saying
indicate
this
WPC
petitioner?
number, my lord, 774.
Where is the order passed in the case of Ramesh Kumar.
WPC 770, well, it is indicated in the, my lord, will take page 27. Series of writ petition were clubbed together and pending writ petitions also was disposed. My lord,
Common
WPC 774 2000.
Judgment, by common judgment, it was disposed of.
WPC
77413, my lord, fourth line it is reflected, my lord. That is petitioner's writ petition. So, my lord, the appellate authority, the division bench allowed that the overage aspect should be ignored and he should be taken back in service. Accordingly, my lord, in the year 2015, we have taken the petitioner back in service. Now, my lord, to count the date of appointment from 2001, my lord, would be contrary to the rules, my lord, because
Absolutely contrary to the rule. Why
Because
have you
he-
accepted this judgment? Absolutely contrary. I agree with you. Why have you implemented this judgment in one case? And you are resisting the other
it
case?
has, I have been informed, not been implemented till now.
That is, we can't help it.
No, that
The
is
court
my,
has to maintain consistency.
my lord.
Why have you not preferred an appeal against this judgment then? We can't, at our suit, will ignore coordinate bench's decision.
My lord,
You
those
are
just,
right. You should appeal against
my
that.
lord, those
When
just,
you appeal, then you take up this point. Yes, take your seat.
No.
I've heard you enough. Content.
And your lordship, regarding basic training, there was direction from the honorable court in the writ appeal, that is page 32. My learned friend has not pointed out that.
Hmm.
In para 15, page 32.
Yes.
In the result, writ petition as well as appeals are allowed. Impugn order on the single judge dated so and so, as well as impugn order dated so and so, issued by deputy commandant, staff of so and so, Assam Rifle are set aside. Respondents are directed to call the petitioner appellants within a period of 1 month from the date of receipt of a certified copy of this order for undergoing the basic training.
So this Prabhu Dayal was also one of the parties in that.
Yes,
What was his writ petition?
it is 774, your lordship, just we pointed out.
774 is Ramesh Kumar. I'm
No,
asking Prabhu.
this is Ramesh. Prabhu is different.
Is he also a part of this?
Yes, your lordship.
What is his writ petition number?
Let me find out, your lordship. Prabhu Dayal. Naresh. The lending staff, so and so, so and so. So Prabhu Dayal's file is not here, no? Because. Yes, your lordship, page 28. WPC 4608. 8 line, your lordship. Page 28. WPC 4608 of 2008. TC so and so recruit. Here is also recruited, not, he's saying that he was not recruited. Here it is recruited. GD Prabhu Dayal versus Union of India.
Hmm.
Same status,
All right.
same position.
I've heard Ms. K. Yadav, learned counsel appearing for the writ petitioner. Also heard Mr. H. Gupta, learned CGC representing the respondents. Full stop. The writ petitioner hearing was appointed as this is what constable appointed as
As a GD,
GD means
Rifleman-
general duty.
rifleman
What is
GD,
the
as washerman. Initial, they are all like GD, no?
petitioner was
GD.
appointed as what?
Washerman.
You're right. Pursuant to a recruitment process undertaken by the Assam Rifles, the writ petitioner was appointed as a watchman on 23/5/2001. Good stuff. However, the petitioner was discharged from service on 31/1/2001 on medical grounds. Full stop. Being dissatisfied with such decision of the authorities, the petitioner had approached this court by filing WPC number 3705 of 2005. What is WPC 3705 of 2005?
It is the initial petition.
That is at page 20.
Page?
65.
Yeah.
So he has filed initially, my lord, page 21. Page 21, WPC 6352, 2005.
6352, 2005.
No, where is WPC 3705?
Yeah, yes, sir. We were file one.
In the synopsis, you have mentioned about WPC
Yes, sir.
3705. Where is that order?
Will you find them? 3705. Yes, sir. I did pay, directed. For direction was to dispose of the representation.
Where is the order passed in WPC number 3705 of 2005? देखो dissatisfied ना लगे like because being aggrieved by such decision to discharge him from service, the petitioner had submitted a representation to the authorities to reconsider his case. However, when no such action was taken in the matter, the petitioner had approached this court by filing WPC number 3705/2005, which was disposed of with a direction upon the Director General of Assam Rifles to dispose of the representation dated 21/1/2004 submitted by the lead petitioner. Full stop. However, the grievance of the petitioner was that his representation was not considered in the correct perspective. As such, the writ petitioner had once again approached this court by filing WPC number 774/2013.
First, my lord, he has filed 6352.
Sorry?
6352 of
Mr.
2005.
Yadav, tell me a date. Your facts are not correct. I cannot dictate a judgment.
Lordship.
You have to give me the facts. Because
This is the order, your
see,
lordship, 705.
where is the you have in your synopsis you have mentioned about WPC number 3705 of 2000. Where is the order? Let us see. Direction to dispose of लिखेंगे तो not being satisfied with the consideration of his representation, the petitioner had once again approached this court by filing WBC number 774/2013, which was dismissed by the learned single judge, along with several other similar writ petitions. Full stop. Aggrieved thereby, writ appeal number 734/2013. No, what is the writ appeal number? Writ appeal number also is not there, correct?
Which number, your lordship?
Writ appeal number.
Writ appeal number, no, all writ appeal were not filed, only few were filed, and writ petition and writ appeal all together were disposed of. So my writ petition number
Writ
was
appeal was
774,
referred,
2013.
the writ appeal.
Writ
along with
petition,
Several writ petitions, including WPC number 774
2013.
2013. was disposed of by this court by order dated 26/10/2014. The operative part of the order dated 26/10/2014 is reproduced herein below. Page 32, double tick to double tick. Thereafter, the petitioner was subjected to another medical board which had declared him fit. Full stop. Consequently, he was taken back in service on 25/6/2015, that is after a lapse of nearly 14 years from the date of his initial appointment, and thereafter the petitioner was allowed to complete the training. Full stop. On completion of training, he has since been absorbed in the Assam Rifles on regular basis. The grievance of the petitioner is that instead of showing his initial date of appointment as 25/3/2001, the same has been recorded as 26/6/2015, and his age at the stage of recruitment was recorded as 40 years. Full stop. Aggrieved thereby, the petitioner has approached this court for the third time, filing the instant writ petition. Full stop. Ms. K. Yadav, learned counsel for the petitioner, submits that the issue raised in the writ petition is squarely covered by several decisions of this court, including the judgment and order dated 1/5/2024, passed by the coordinate bench in WPC number 7201/2018, record of Prabhu Dayal versus Union of India and others, wherein the learned single judge, after examining the plea raised by the petitioner therein, seeking similar relief, had allowed the writ petition. Therefore, this writ petition be also allowed by this court. Full stop. Mr. Gupta, learned CGC, on the other hand, has strongly opposed the submission of Ms. Yadav by contending that the facts of this case are distinguishable in nature, inasmuch as in the case of Prabhu Dayal Supra, the writ petitioner was a recruitee, meaning thereby that his discharge on medical ground was at a stage when he had partially undergone the basic training, whereas in the present case, the petitioner was discharged on medical grounds at the threshold, that is, even prior to his enrollment as a Assam Rifle personnel. Full stop. By referring to Rule 15 of the Assam Rifles Rules, 2010, Mr. Gupta has further argued that from a bare perusal of the rules, it would be clear that until such time the name of an employee is enrolled, he cannot be deemed to have been enrolled as an employee of the Assam Rifles. Under such circumstances, the question of granting seniority to the petitioner with effect from his original date of appointment, that is 23/5/2001, would not arise in the eyes of law. Full stop. In the case of Prabhu Dayal Supra, the writ petitioner therein was also recruited by the Assam Rifles on 23/5/2001, but he was discharged on but just like the writ petitioner, he was also discharged on medical grounds. Subsequently, in terms of the directions issued by the division bench of this court by order dated 26/10/2014, whereby the writ petition being WPC number 4608/2008 was also disposed of. by the learned division, by the Honorable Division Bench, along with a batch of similar writ petitions, including WPC number 774/2013 instituted by the petitioner. The said writ petitioner was reinstated in service. Thereafter, he had approached this court by filing WPC number 7201/2018, raising a similar grievance. Full stop. By the judgment and order dated 1/5/2024, passed in the case of Prabhudayal Supra, the learned civil judge had made the following observations. Para 13 में पूरा लिखिए. Para 13 में पूरा, para 17 में लिखिए. Ab dilo. From a reading of from the aforesaid decision rendered by a coordinate bench in the case of Prabhudayal, this court is of the unhesitant opinion that the petitioner's case is squarely covered by the directions contained in the case of Prabhudayal Supra. Full stop. Mr. Gupta has made an attempt to distinguish this case by contending that the writ petitioner herein was neither enrolled nor recruited, whereas in the case of Prabhudayal, he was discharged at the stage of undergoing basic training, and therefore he was a recruitee. Full stop. This court is unable to countenance such argument purely on account of the fact that the issue involved in both these proceedings is not as regards the stage at which the discharge was made, but upon reinstatement, but the grounds on which the discharge was made, and also upon reinstatement, whether the benefit of initial date of appointment, that is 23/5/2021, should be granted to the petitioner. Viewed from that angle, this court is unable to find any distinguishing feature in both these proceedings. Mr. Gupta may have some justification in arguing that after long lapse of time since the date of discharge, the question of granting seniority, even if notional, cannot arise in the eyes of law. However, the fact remains that the respondents have not preferred any appeal against the order judgment passed in the case of Prabhudayal Supra. In view of the above, for the sake of maintaining judicial discipline, this court cannot take a different view in this case on the same set of facts. Rather, the decision of the coordinate bench will be binding on this court. Therefore, this writ petition has been disposed of in terms of the observations and directions made in paragraphs 13, 14, 15, 16 of the decision rendered in the case in Prabhudayal Supra. Parties to bear their own cost. Yes.
May I please, Your Lordship? The petitioner was a master weaver under the Handloom Research and Design Center, under the Director of Handloom and Textile. And thereafter, my lord, he was redesignated as information officer, that is annexed to page 12. The word is redesignated. So he accepted that redesignation
within the department and discharge his duty. But only grievance is that in other departments, some of the departments, this information officer has been drawing the grade pay and basic pay something higher than this petitioner. So he claimed that benefit, my lord, for which one justification has been given in favor of the petitioner, page 13, my lord. Officer in charge.
Page 13.
Yes. So there are some points justifying for the enhancement of the information officer, such as the duty of the petitioner as information officer is to be classified or catalog the books, journals, books to read as per their needs, and some more things. This is issued by the officer in charge. Thereafter, my lord, page annexes 3, page 14.
Just a minute,
My lord.
So what is the pay band and grade pay applicable to information officer? Where is it available?
My lord, difference is at page 15. Left portion is present salary, right portion is higher payment. Only the grade pay is of 3,300 and it should be 4,700. That is one difference. And the rent and DA is 1,000 more. And it is as per the ROP 2010.
Yes, what do you have to say? Who will say, finance or?
Both of us.
Both of us will attack him, huh? This is not.
This is not exactly that, my lord.
We have, at the end of the line, my lord, we have rejected the proposal, so I will submit on that.
At least my lord, at the end of the day, finance has to give the concurrence, my lord.
Yes.
My lord, here we stated in our affidavit that he is the master waiver, my lord. We just redesignated that name as information officer by this order, my lord. And with regard to, my lord, his pay band, that is never touched. We did not intend, my lord, government has never had any intention of upgrading that post to other. Like, my lord, say, take the instance of inspector of police and inspector of broiler. My lord, inspector of broiler, that is a my lord, feather cutter. It's an equivalent director. Whereas inspector of police is a police. Only redesignating or a name, my lord, nomenclature would not affect the payment, my lord. Here, my lord will go to my affidavit last page. I have only one annexure. Affidavit filed by respondent number 1. Here, I will just read the, my lord, his order by which he was redesignated, my lord. The intention of the, my lord, authorities was very clear, my lord, and even he knew it and he accepted it, my lord. And now, my lord, the petitioner is
the order of 31st December.
31st December, my lord. My lord, here the governor of Assam is pleased to redesignate the 2 posts of Master Waiver of Handloom Research and Design Center, Guwahati, which was originally created by such and such, dated 10/8/60 as Research Assistant Textile Testing and Information Officer HRDC in the scale of 5,200 to such and such, my lord. And the next is also same, my lord, redesignated. Sri Apurva Vaishya and Jagat Chandra Vaishya presently holding the post of Master Waiver in HRDC hereby redesignated as Research Assistant Textile Testing and
So is this under challenge? Is this?
This is under no. He is not challenging this order, my lord. He just wants that he should get a higher pay grade, my lord. That is his prayer, my lord. But, my lord, we never had any intention, my lord. We just changed the name, my lord, designation. Otherwise, my lord, it is very much apparent from the order itself, my lord, that We never intended to.
So just a minute, just a minute. Master waiver also had the same
Same.
scale, etc. Everything was same.
Yes, everything the same, my lord. We just redesignated nomenclature, just we changed it, my lord. Nothing more, my lord. That is what we stated in our affidavit. I will just read my affidavit, my lord. In para 4, I am reading, my lord. That with regard to the statement made in such and such, the writ petition of Japan states that it is a fact that the government and handloom and textile department redesignated the post of petitioner as information officer HRDC by such and such dated 31/12/13. However, the scale of pay of the petitioner was kept the same with his earlier post of master waiver. Thus, the government had no intention of upgrading the post of master waiver held by the petitioner. It was only redesignation of the post. We never intended to, my lord, upgrade that master waiver position to something else, my lord. We just redesignate, my lord. That's it, my lord.
All right.
So now, only basing on this, my lord, he cannot invoke that some in other department, information officer is getting this payment, and we have to. For that, my lord, the rule has to. There has to be a rule, my lord. We don't have any such, my lord. From day one, my lord, and
Yes.
and they decline, my lord. Finance, my lord.
You have also filed affidavit.
Yes, ma'am. We have also filed affidavit. That affidavit is filed, my lord, on behalf of respondent number 3. The deponent is one Kobin Chandra Bedborough. Their lordship we have clearly spelled out, my lord, that it was only a redesignation, and even that was done, my lord, without concurrence of the finance department. So he has to be happy and contented with what he is getting. Now, my lord, he had moved the pay commission at that point of relevant point of time. My lord, when my lord
You submit representation before the pay commission.
no, he had already submitted that the finding lordship will find that annexure A of that affidavit, page 6. Page
Which
6,
affidavit?
My affidavit, finance department's affidavit. Lordship will kindly see that affidavit. Page 6, annexure A. Lordship got it, my lord?
Yes.
My lord, this is the recommendation of the pay commission with regard to various aspects, my lord, because various representations were made by different associations and including a writ petitioner. Their lordship will kindly see, my lord, down below 1.13 handloom and textile department. Lordship got it, my lord. Lordship will kindly see the view regarding the case of Sri Jagat Chandra Boboisya. Now he is the petitioner out here. Information officer so and so. The commission is of the view that the department should examine the case to ascertain the rank that Sri Boisya might have reached in the cadre to which he belongs before his post was redesignated in 2013. Accordingly, a proposal for fixation of his pay be worked out and submitted to the finance department for approval. So his representation before the pay commission was that since I am my posts have been re-designated and there are posts of information officer, not my lord in this handloom textile, but in some other department. So kindly give me that pay scale. It was plain and simple. So he cannot, the commission opined that it cannot be done in a mechanical manner. It has to be first of all ascertained whether any cadre post exists. Now, admittedly, my lord, there is no cadre post of information officer, my lord, in the handloom and textile department. Nonetheless, he has been redesignated in that effect, carrying the pay scale. Now, lordship will kindly mark one aspect of the matter in the repetition as well as, my lord, in the affidavit file by the handloom and textile department. It is absolutely silent, my lord, what was the pay scale he was drawing and how the petitioner came to be appointed. We assume that it was a regular process. Even except only one statement, the opening statement, opening paragraph in the writ petition, where he says, the first paragraph, the petitioner joined the services master waivers at handloom so and so, so and so, so and so. It is to be stated that in the wake of time, petitioner became the senior most master waiver. Even except this statement, my lord, there is no material on record to show, my lord, how he came to be appointed, what was the pay scale given to him, all these aspects of the matter. Now, under that circumstances, my lord, since no concurrence of the finance department was taken, even at the time of redesignation, one aspect. Secondly, my lord, the post cannot be equated. And thirdly, my lord, he is not entitled because there is no specific recommendation. There is no pay structure available in the ROP. So these are the three basic points, my lord.
And these are financial matters, my lord. Lordship will keep it to the wisdom of the determining authority. So this is how, my lord, it is. Because it is not a case of upgradation. He is claiming as if his post was upgraded. We could have understood the situation, my lord, if the authorities have upgraded, and then, my lord, the petitioner is deprived. My lord, we have noticed them. But here is a case only on papers, my lord, not on field.
My lord, I have just 3 points.
So on what basis you are claiming 4,700 grade
Mine.
pay?
First point is that I was the master weaver senior most. Annexer 1 has been annexed, so there is no doubt about it. Thereafter, I was designated. That word is also accepted because that is already accepted by me and duty has been discharged. And since now I have already retired. So second point is this, my lord. I have passed one document, my
But
lord,
why
that-
don't you make the court's inquiry as the first point? The court is asking you that what is the basis on which you are claiming a higher grade pay?
Yes. First point is this document, my lord, serial number 7. Information officer post is there at the Handloom Research and Design Center. Serial number 7. And
Yes.
so it is not that post is not there. And my post is at Master Weaver at page serial number 12. Second point is, my lord, there are other departments, 2 departments in the additional affidavit I have filed.
Answering the question of the court. I'm asking you on what basis are you claiming 4,700 as your grade pay?
My lord, may kindly come to additional affidavit. I
Can
have
you
annexed-
please say it, assuming that I don't want to read your affidavit, can you verbally tell the court, you
Yes.
must know what is your case?
Yes.
Say simply, no, because my contemporaries are getting it, or there is a provision in the rule. You are unable to say going here, going there. We can't waste time like this.
My lord,
What
sorry.
is on what ground you are claiming? What is the basis of your claim? Say that. Then you go to the document to establish your point.
My lord.
But you can't even say what is the ground.
My lord, first claim is that I have been doing much workload that is explained in the
So that
page
can't be a
30.
ground for the High Court to.
And second point is, my lord, other department, for the same post, this amount has been already drawn by that information
that
officer.
other department, the High Court cannot.
So my lord is already well aware that there are so many judgments that similar kind of work, similar payment is to be given under the same.
So you mean to
government.
say all information officers in this country should get the same pay scale? Is that what your case is? Whether it's this department, that department, every department, the moment the name information officer comes, everybody should get the same pay scale. Is that what your case is?
My lord, as I already, that is correct, my lord. But the thing is that as I already inquired, in workload and the structure of information officers are same in the all departments. And there are so many cases of Supreme Court also as well as High Court also. That for similar work, similar payments should be given. And earlier the director of
So
employment.
you have
Tax Claim-
submitted any representation?
Yes,
Where is it?
page 28 annexer 11, my lord.
So that is the anomaly committee. That is now gone. That was anomaly committee after the seventh
Yes,
pay
gone.
commission.
It is gone. And
No,
therefore,
in that
What has happened to this?
29 page, the prayer for
No, this-
enhancement under ROP 10 is
this
also
was
there, my lord.
considered, this was considered, and this is the recommendation which the chief has just now seen, my lord, in the finance department affidavit.
And they are saying that no service rule is there. Whereas that post is already a sanctioned post established in the year 2006, 1960, my lord. So now they are saying that there is no service rule. That is also to be looked into. That is
Yeah.
all, my lord.
Huh?
That's the 3 points I am trying to convey, my lord. Nothing else. I am admitting the redesignation. Only thing is that give me some more benefit. not only to me, for the further,
What can the court do about it? You are now retired, what benefit you can get now? You have already retired.
that is
So
also
you
correct,
retired when?
2022. Back that, if I get,
Oh.
area could be given with retrospective.
They don't want to give front date and you want back date. No?
It's also
Ask Mr. Bapujari.
No, my lord, legally.
He
it
doesn't
is,
want to
my
pay,
lord.
people are now working and you think they. Anyways, I don't think you have any case, so. Can I dictate the order?
Well,
Okay. Take down. Heard Mr. M. Das.
DK Nath.
TK Nath, sorry. TK Nath. Direct Council. Your name is there, yes.
It is there.
DK Nath, DK Nath.
DK Nath.
Direct Council.
Diganta Kumar Nath.
So heard Mr.
One and two percent.
R. Dhar, Learned Standing Council, Handloom and Textile Department, Assam, appearing for the respond numbers 1 and 2, and Mr. R. Bapadari, Learned Standing Council, Finance Department, Assam, for respond number 3. The writ petitioner hearing was originally appointed as master waiver. Master waiver within court below. In the Handloom Research and Design Center under the Directorate of Handloom and Textile, Ambari, Assam. First, while discharging his service as above, the post of master waiver within courts was redesignated by the authorities as within courts information officer, unquote, wide notification dated 31/12/2013 issued by the competent authorities. It was clarified that the post of information officer would carry the pay scale of rupees 5,200 to 20,200 with grade pay of 3,300. The petitioner has accepted the order of redesignation of the post of master waiver and continued to discharge his duty as such. This court has been informed that during the pendency of this writ petition, the petitioner has retired from service with effect from
Exact date, I don't know,
In the month-
year 2022, I think.
in the year 2022 upon attaining the age of superannuation.
Yes.
However, the instant writ petition was filed at a time when the petitioner was in service, claiming the benefit of higher grade pay of rupees 4,700. The primary contention of the writ petitioner is that the nature of duty of an information officer is different from master waiver and involves greater responsibility. That apart, the information officers serving under different other departments are enjoying the benefit of higher grade pay. Hence this prayer. Responding to the above, Mr. Dhar. Yeah, then you write. The respond number 1 and 3 have filed separate affidavits contesting the case of the petitioner. According to the counter affidavit filed by the respond number 1, this was a simple case of redesignation of the post of master waiver without there being any intention to upgrade the post. In such view of the matter, the petitioner cannot claim higher financial benefits due to redesignation of the post. In the counter affidavit filed by the respond number 3, that is the finance department, it has been stated that the redesignation of the post of master waiver was carried out without obtaining the concurrence of the finance department. Full stop. As such, the question of any alteration in the pay structure would not arise in the eyes of law.
And further, there is no service rule to that effect. We have.
Mr. Nath has argued that since it is not in dispute that the post of information officer does exist in the Department of Handloom and Textile, and considering the workload of such post, the information officer was entitled to a higher grade pay, which aspect of the matter has not been considered by the authorities in the correct perspective. Mr. Dhar, Learned Standing Council, Handloom and Textile Department, Assam, has reiterated the stand of the authority as projected in the affidavit and submits that mere redesignation of a post would not entitle the petitioner to a higher pay scale. Mr. R. Bapujan, Learned Standing Council Finance Department, has also argued that there is no service rule incorporating the post of information officer, and merely because information officer of another organization is drawing a higher pay scale, that cannot be a justification for the authorities to consider the prayer made by the petitioner. Mr. Borpujari has further submitted that the representation submitted by the petitioner and another similarly situated.
Yes.
You had yourself submitted or another person was also there?
He has submitted.
Pay anomaly committee?
He has submitted.
The representation submitted by the petitioner before the pay anomaly committee was also declined after examining his claim. Therefore, there is no good ground for the court to interfere in the matter. I have considered the submissions made at the bar and have also gone through the materials available on record. It is not in dispute that the initial appointment of the petitioner was in the post of Hidden Courts Master Waiver in the Handloom and Textile Department. This post was redesignated as Information Officer. However, the post of Information Officer carried pay scale which is equivalent to the post of Master Waiver. In other words, there was no change in the terms and conditions of service of the incumbent holding the post of Master Waiver after its redesignation as Information Officer. Not only that, there is no indication even in the service rule that the post of Information Officer would carry higher pay scale or would be entitled to higher grade pay as compared to the post of Master Waiver. The aforesaid position was made clear. Now, the aforesaid position clearly appears from the notification dated 31/12/2013, by means of which the post of Master Waiver was redesignated as Information Officer. The petitioner has not challenged the notification dated 31/12/2013. Under such circumstances, and merely because the post of Information Officer in another organization carries a higher pay scale, this court cannot issue a writ of mandamus directing the respondents to extend the benefit of higher grade pay to the petitioner. More so, several years after his retirement. For the reasons stated herein above, this writ petition is held to be devoid of any merit. The same is accordingly dismissed.
May I please your lordship? In this case, my lord, I am having some preliminary objection regarding the maintainability of this case. Number one, about the jurisdiction of this Honorable High Court. Actually, this case should have been filed before the Meghalaya. And secondly, my lord, this matter is already decided by the Honorable Supreme Court. And beyond that, if your lordship open this file, I am having some today little bit of health problem, by the way. I am having some ache on my tooth. So 2-3 days, my lord, I pray for this.
Your third ground is the strongest ground.
Yeah, no, my lord. Otherwise, I won't be able to speak for a longer
This is
period.
good enough a ground to have dismissal of the writ.
So,
In a final hearing, maintainability will not be gone into. But if you are unwell, then we can have it.
yes, yes. And secondly, Supreme Court has already decided this issue, my lord.
Are you aware of the judgment of Supreme
My
Court?
lord, I would differ with it. There was no.
Maybe.
Are you aware of the judgment?
No, no, he would be relying on the judgments that I have placed before this Honorable Court, so that.
Mr. R. Mohinder, Legal Counsel for the writ petitioners. Writ petitioners is present on the request of Mr. Y. Dole, learned CGC, appearing for the. You are not CGC. Are you appearing as CGC?
Yes, sir. Senior CGC.
Senior CGC appearing for the respondent, citing health grounds. The hearing of this matter stands adjourned for 3 weeks. List accordingly. 3 weeks.
But that may be given, my lord.
When do you want it?
Any day.
8th of May. 8th of May.
Yes. Oblige.
Oblige.
List again on 8th of May. Item 12.
This relates to a disciplinary proceeding, my lord,
Hmm.
where the petitioner was terminated from service for being absent from for overstaying his leave.
Hmm.
What had happened is the petitioner was given a certain amount of leave, and thereafter he wrote an application to the commandant saying that he was facing harassment by his immediate superior officers, and therefore he was not in a position to join back at the battalion at the company that he was allotted, and allotting him any other company would in fact enable him to join and continue his services. A disciplinary proceeding was initiated against him by issuing him a memorandum of charge. He prayed for issuing him an English version of the charges because he was not conversant with Hindi at that point of time. The inquiry officer was also intimated that he was not being able to attend the inquiry because of the difficulties. The inquiry officer proceeded ex parte. Towards the end of the inquiry proceedings, the respondents have brought on an affidavit, a letter, saying that an English version was in fact given to him. However, that the absence of that English version of the memorandum of charge itself had been taken up in the appeal stage also, which was never answered to by the respondents. Now, my lord, on the basis of the ex parte inquiry, he was terminated from services. The only prayer of the petitioner now would be setting aside of the inquiry proceedings, allowing him to participate properly, find out the grounds why he was not allowed to, he could not have joined back. Perhaps.
So how long will you take? You can conclude it. I'll not make it parted for certain reasons. Can you conclude it today?
I have to go through records, my lord. It will take me around 40 minutes to maybe persuade. It would take a long time.
You have the records.
Yes.
Okay.
Or
You have to
otherwise,
conclude it today because I'll not make it parted.
should we make an attempt, my lord, permits?
Up to you. Up to you.
If a date is fixed, my lord, there is no difficulty also.
Whatever you want. You want to argue, you
Let
argue.
it be on, my lord, could it be on the first week of May or second week of May, my lord?
6 already I have paid us. It can it be on 8th?
2018 matter, 17 he is out of service. So on the 8th of May would be fine.
8 of May.
No difficulty. The other matter is also.
On the joint request of so-and-so and so-and-so for the both the parties, let list this case for hearing again on 8th of May 2024.
Okay.
This can be also fixed on 8th of May. Again, a disciplinary proceeding will go through the entire process, entire disciplinary proceeding up to
15th of May.
15th.
So nice. Joint request 15th.
I'm deeply obliged.
Okay.
This matter pertain to the Oil India, my lord, about the concession given to SCs and SCs in promotion, my lord. Other side is. I will. Okay.
Lordship, my senior is on the way.
Who is your senior?
MK Chaudhary, your lordship. He's appearing on this case.
So you'll be able to complete it today?
Can be complete because he's retiring on 30th of April, my lord. I've submitted a written argument, my lord. Not argument written, just the points, my lord.
Yes.
Yes. Thanks. Thanks.
Your client is now in grade D.
In grade D, my lord.
He was promotion from a prior date.
From 1st of January 2021 on completion of 5 years. He has been given the promotion on completion of 6 years.
1st of January
2021.
He has given promotion on 1/1/2022.
22. With effect. He was promoted to grade B, my lord, to grade C, my lord, on 4/10/2016.
He was promoted when?
By order dated 4/10/2016, my lord, with effect from 1/1/2016. Page 45.
Order dated?
Order dated 4/10/2016. With effect from 1/1/16.
Where is the order? Page number?
45, my lord.
And where is the order of promotion with effect from 1/1/2022?
My lord, page 46.
Just a minute.
My.
So in page 46, where do you find that it is with effect from years?
My lord, the first line, first sentence, my lord. First, we are pleased to advise that you have been selected for promotion to oil grade
Okay.
D in level.
So why do you say it should be 1/1/2021?
My lord, the span for promotion, for consideration for promotion, my lord, is 5 years and 6 years. If my lord comes to page, in my written submission itself, my lord takes it up, my lord. Page 52.
Page 52 of?
Page 52 of the writ petition, my lord. If lordship takes up the written submission side by side.
Written submission is there.
My
Yes.
lord. Page 52, my lord,
Hmm.
of the writ petition.
Yes.
My lord, the eligibility, 2.2, my lord. Eligibility, A span, number of calendar years to be promoted in the existing grade as on 31st December for eligibility for promotion to the next grade will be as under. Serial number 3, my lord. C to D, lordship will see the rightmost column. 5/6, there's an asterisk mark, my lord. That asterisk is selectivity ratio, which will be explained at 2.3 below. Now, 2.3b, if lordship comes to the next page, towards the bottom of the page, my lord.
Yes.
Promotions from grade C to D and D to E will be based on selectivity ratio as under. A common seniority list of all eligible candidates will be used for promotions from grade C to D and D to E. Next page, my lord. The promotions will be based on selectivity ratio as under. That is promotion from C to D, selectivity ratio 70 to 30. 70% of executives rounded off to the next higher integer will be promoted from the date of eligibility, that is 1st of January as per merit. The remaining 30% executives will be promoted from 1st of January of the following year, subject to meeting all eligibility conditions. The selectivity ratio will be applied separately. So 70% of those who are there, my lord, they will be promoted on completion of 5 years, and the remaining 30% on completion of 6 years.
So they have put you in the 30%.
They have now, I was in the 70%, but to accommodate persons from SC and ST, my lord, I was removed and put in the 30% bracket.
Okay.
Now, my lord may come to the at page 57, my lord, as to how this is to be applied.
Yes.
Lordship sees the table composition of DPC. There is a sentence just below that table, my lord. Concessions to SCs and STs in posts filled by promotion by selection will be regulated by DP OM number so and so dated 31/1/2014 or is amended from time to time. So there is no reservations for SC and ST. It is only the concession as per the memorandum of 31 January 2014.
So according to you, some SC/ST candidates have been brought into the 70%.
Minor.
As a result of which you are out of the
minor
70% and you have been brought into the 30%.
Minor.
Now, if your contention is to be accepted,
minor,
then somebody has to be downgraded.
Minor, there are no fixed vacancies in this post. For up to grade B and as well as grade D, minor, there are no fixed vacancies. The persons completing the number of years, they are automatically promoted. Now,
So then this 70% and 30% is calculated on what basis?
On completion of on the merit basis, my lord.
70% of what?
70% of all the persons in grade C who meet that completion of 5 years or 6 years. All those who complete 5 years, from them 70%.
So if there is no fixed basis, then why do you say that because of SC candidate you have been taken out?
My lord.
There has to be some quota, otherwise why should
No, there is no, if the concession, if lordship sees, there is no reservation which is mentioned. If my lord comes to the page 69.
No, Mr. Nair, I'm asking you a very simple question.
My
You are saying that there is no cap, there is no ceiling. Correct? If that is correct, then if you are eligible, you could have kept and other people also could have been accommodated.
Exactly. That is what they are doing
So
now.
why have you been, are you saying that you have been thrown out of 70% category because of more candidates in 30%? Are you saying this?
No, my lord. The persons who were in the 30%, they could not have been in the 70%, but by application of the concession, they have been brought into the 70% by downgrading me. My lord, I understand.
There has to be a limitation somewhere. Otherwise, why should you be downgraded to bring in someone from 30% from the SC category? Not 30%,
my lord,
whatever.
it works like this, my lord. Those who complete 5 years, the list is there, my lord.
Let's take this case.
Yes.
There are 10 candidates who are eligible.
My lord.
7
my lord,
will come in the 5 years.
My lord.
3
my lord,
from the 6 years.
My lord.
Correct?
My lord.
So out of these 10, your client was 1.
Yes, my lord.
He was from 6 or 5. Which category? 5.
5 or 6, within 7.
He was in the
5 years, 5
category.
years, 5 years, 5 years.
So he was within 7.
Yes, my lord.
Then why he was not given?
My lord, because they applied this concession incorrectly, my lord. in order to accommodate the concession category persons, my lord, I was removed to bring in them. If my lord comes to page 53 once again, my lord. Page 53 once again, my lord. Vacancy, my lord. 2.3A, my lord. Promotions from grade A to grade B and B to C. All executives meeting the eligibility criteria and securing minimum 60% as per selection criteria will be promoted. All executives, my lord. There is no fixed vacancy in grade D. This is in respect of A to B and B to C.
So now please show that you had met the criteria.
My lord, I have. In fact, they have also admitted that I was within that period.
Where is the admission?
My lord, the item. My lord may come to 101, my lord. It's a RTI
101.
reply. 101 RTI reply.
Yes.
My lord, the information furnished. The score of the last ranked executive as per merit promoted with effect from 1/1/21 is 92. And the lowest score promoted with effect from 1/1/21 based on concession as per circular so and so is 79. So. My lord, in their affidavit, if lordship comes to page 135.
Now, what are you showing from this 101? What is to be seen from here?
My lord, in 101, they say that the last person who has been promoted on the basis of merit is, my lord,
92.
92.
And what is the rank of your client? How much?
My lord, my rank in their affidavit, if lordship comes to my lord, is 90.2.
So then,
now, if my lord comes to page 135.
No, we'll go to 135, but are you challenging this 101?
No, my lord, I'm not challenging.
Then you are below the cutoff mark of.
My lord, cutoff mark just to accommodate persons from the SC and SC, they have put in as 92. But of the total 70%, I come within the total 70, the first 70%, my lord, at 90.2.
These are two cumbrous exercises. We can't do it.
My lord,
that you make a representation before them.
My lord, we have done, but they have been, they have
This
rejected.
is not a calculation the court can.
My lord, there's another aspect, my lord. The concession, the office memorandum, nothing has changed. If my lord comes to page 69.
Page?
69, my lord. The present policy.
I've understood, Mr. Nair, but this exercise, this court will not do.
No, my lord. I'm not
possible and will not do.
I'm not requesting lordship to make the calculation.
Calculation 90,
No, my lord.
92.
No, my lord. I'm not on that, my lord. It's admitted, my lord, that we are within the 70% and we have been brought back. It is they are not going to dispute that.
Yes, but you have not scored 90 but 92, which is the cutoff.
92, my lord, they have promoted not because I was not within the 70%. To accommodate persons from SC and ST, they have put it at 92. But I am within that 70%. That they have also admitted. If my lord comes to page 69.
That declaration this court cannot give.
No, my lord.
You can argue, but
I am not on that, my lord. I am not on that, my lord. If my lord comes to page 69.
Page?
69 of the present promotion policy with effect from 2021. Just below the table, the same sentence, my lord. Concessions to SCs and STs in post fill by promotion will be by selection, will be regulated by DPOM so-and-so dated 31/1/2014 or is amended from time to time. This sentence after this, my lord. This concession will be in addition to the selectivity ratio. That is what I am on, my lord. There is no change in the concession given, no change in the office memorandum or the presidential directive. Now, what they are doing now, my lord, is they are not removing persons from the 70% on merit. They are automatically promoting the persons to whom the concession is applied in addition to the 70%. This is not a change in policy because it is based on the
Who are
office.
the people they have brought in addition to 70?
My lord, I have made them as private respondents now.
Is anybody appearing for them?
Mr. Kayal was appearing, my lord.
Mr.
Kayal was appearing. From respondent number 7 to 11, my lord. 11. 11 retired. 11 has already retired in the meantime.
But where is Mr. Kayal? Is he? It also is option.
The present policy, my lord, shows that how this concession is to be correctly applied. Because there cannot
Mr. Nair,
be, my lord.
you go and tell them how to apply it correctly. These are not matters the read code can do much about it. What is correct, what is incorrect. You have to show us where is the violation of your right. And correct, incorrect is not none of the issues. We cannot go into this. And this appears to be too cumbrous an exercise.
My lord, this is actually my second leg of the argument. The first leg, my lord, is the concession, the presidential directive is to be applied.
That's correct. So you can make out a straightforward case, court can examine. That person scoring lesser mark than me, but on the same category have been brought in. Or if you can show that there was a quota, this was the number beyond which they could not have brought in SC/ST category. None of these things are there in your case. You are only arguing on abstract basis. We cannot pass judgments on these abstract basis. That's the problem.
There is another aspect, my lord.
You give me the best aspect you have.
My lord, this presidential directive, if lordship looks at the presidential directive, the presidential directive is based on salary, my lord. If my lord comes to the presidential directive, the folded page, my lord.
Page number?
My lord. My lord, page 100 and 104, 103, 104. 105 of yours. 5 of yours. Page 103, my lord. The folded page. Clause 14, my lord. Towards the bottom on the right side. Promotions by selection within Group A, Class 1. In promotions by selection to post within Group A, Class 1, which carry an ultimate salary of rupees 2,250 revised to 5,700 per month or less, there is no reservation except a concession, namely that scheduled caste, scheduled tribe officers who are senior enough in the zone of consideration for promotion so as to be within the number of vacancies for which the select list has to be drawn up would be included in that list, provided they are not considered unfit for promotion. This position in the select list would, however, be the same as assigned to them by the Department Promotion Committee on the basis of their record of service. They would not be given for this purpose one grading higher than the grading otherwise assignable to them on the basis of their record of service. Now, this was modified, my lord, at page 105. Page 105 in 2004, my lord, it was made 18,300. It is only on the basis of the salary. Now, the
selectivity ratio, according to you, has nothing to do with SC/ST concession. Selectivity ratio is just who will come in the 5 years category, who will come in the 6 years category. Then you are saying there is no fixed number of vacancies.
There is no fixed number.
Then why should you go out if somebody else comes in?
That is why I should not have gone out.
Where is the proof to show that you went out because of that?
My lord, you have to affidavit. in their affidavit in opposition, my lord. If my lord comes to page 135.
Yes.
They have given a table, my lord. This is the affidavit filed by All India. At serial number 6 is the petitioner, my lord. Mintu Borkakoti, General, 90.2. Then lordship will see the remarks column. Displaced due to SC/ST promotion, promoted with effect from 1/1/22 instead of 1/1/21. I have been displaced from the 70% because of the SC/ST promotion. And my lord, if lordship sees the person just below me, my lord, serial number 7, promoted with SC/ST concession, initially on merit list within merit rank 96, but got displaced due to concession applicable available to SC/ST
So
candidate.
any general category candidate scoring lesser mark than you?
No, my lord. No, my lord. No general category candidate. It's only the SC/ST candidates who have been promoted by displacing me. No, these are in their list which they have given, my lord. If lordship sees below me, all are SC/ST candidates. There's another person, my lord, OBC category person who has been displaced. In that table, my lord, serial number 8, not general, but OBC, my lord. He has also been displaced due to SC/ST promotion.
So your case is you've taken SC/ST but without displacing.
Without displacing.
That will be relevant if you can show that minus SC/ST, you would have still made it.
Yes, I would, from their remarks, my lord, that I have been displaced because of applying the SC/ST promotion. Otherwise, I'm in the merit list. I'm in the 70%.
All right. Yes, anything else?
That is the first, that is the second submission actually, my lord. The first submission, my lord, in promotions from group C to D, my lord, this SC/ST concession could not have been applied. That is my first submission. If my lord has seen the office memorandum of 91, thereafter 2004, it was raised to, my lord, 18,300 at page 105, 106.
What is the second submission?
The second submission is in fact what I submitted earlier. That is, this concession should have been applied in addition to the, assuming that the concession is applicable, which is what they are doing now. Under the 2021 policy, my lord, they are not removing any persons.
Okay, and your representation has been disposed of?
Has been dismissed, my lord. My lord may come to 107, the office memorandum which is referred to in the policy.
Yes.
In the previous office memoranda, lordship has seen the salary up to which this concession can be given. Now, the undersigned is directed to refer to Department of Public Enterprises OM of even number dated so-and-so 2004 on the subject mentioned above, and to say that consequent upon implementation of the 6th Pay Commission recommendation, DOP has issued office memorandum number so-and-so dated 7 June 2013, saying that the new ceiling for concessions in case of central government employees would be carrying a grade pay of rupees 8,700 or less. Since no equivalence can be established between the CDA and IDA scales, more so because scales have been merged into four pay bands under the CDA pattern, the earlier grade identified in 2004 for CPSE employees, that is E5, may continue to be the reference post for purpose of implementation of concession to SC/ST employees in posts filled by promotion by selection. So in respect of IDA scales, that the industrial development, DNS allowance, my lord, it is grade E5. Now, what is this grade E5? Under the revision of pay, my lord, recommendations, the office memorandum issued in 2017. If lordship turns to the next page, lordship, the date is there, 3rd of August 2017. And the scale is given, my lord, in annexure 1 there to at page 115. E5, my lord, at page 115, my lord, annexure 1 to this office memorandum. The scale of E5, my lord, is 80,000 to 2,20,000. E5, my lord, and revised, the rightmost column is the revised scale. 80,000 to 2,20,000. Now, in oil, my lord, the next page, my lord, page 26. In page,
Mr. Secretary, I will wake up. Be a little low.
it's late in the afternoon, my lord.
Is it a signal that it's time to wind up?
Well, just one particular one, my lord. Page 116, my lord, the pay scales in oil. The grades are given in the second column, my lord. The scale corresponding to grade D, the revised scale, my lord, is 90,000 to 2,40,000. And grade C, my lord, is 80,000 to 2,20,000. So, my lord, as per the OM, it is to be given to up to grade E5. E5 carries a scale of 80,000 to 2,20,000. So it has to be applied only to grade C. It cannot be applied to grade D. It is a promotion to grade D. Now, this case projected by the respondent, oil, my lord, is that they have different scales than that of the IDA pattern. And they have calculated the corresponding grades, grade-wise, and said that it is applicable to grade D. That is their case in the affidavit in opposition. But, my lord, the presidential directive as well as the office memorandum, they are not on grades. They are on the pay, my lord. And since the correspondence of because of existence of different grades in different PSUs, my lord, the government has said it is to be applied to grade E5, which carries a scale of 80,000 to 2,20,000. So they cannot override that. That is the first leg of my submission. So therefore, my lord, this concession cannot be applied to grade for promotion to grade. And the second leg of my submission is assuming it is applied to grade. That would be my second leg of submission. Assuming it is to be applied, my lord, what they are doing now is the right approach, my lord.
How do you know what they're doing now?
My lord, that page 69, my lord, of the present promotion policy. Page 69. There's no change in reservation or the directives or the office memorandum. Page 69.
Page 69 says this, and where is the earlier policy?
My lord, page 57. That last sentence is missing in page 57. Page 57, just below the table, my lord. Concession to SCs and SCs imposed by promotion will be regulated by the OM of 31/1/2014. Page 69 is also the same, and they clarify, my lord, this concession will be in addition to the selectivity ratio because it is on application of the OM. They are not introducing anything new, my lord.
And this promotion policy came into effect when?
From 11/11/2021.
So before that, you were.
Before that, it was there. But, my lord, what I am on, my lord, this is not a change in the policy. It is the same OM which they are applying. I can understand, my lord, if there is a change in policy. It is not a change in policy. It is the same OM, the same presidential directive which is being applied. Assuming it can be applied to promotions to grade D, my lord, then also, my lord, it is to be in addition to that. They realized their mistake after I submitted my representations. I would be retiring, my lord, on 30th of April this month, my lord. My lord, I would not get the benefit of any back wages or anything, but what I would be on, my lord, is of the fixation notional benefit which I would gain in the time of my retirement. That is what would be applicable to me. And my lord, other persons also from now on, they are applying the same policy. Same policy with the clarification of not removing anyone else. Right, that is my submission. First of all, my lord, it cannot be applied for promotion to grade. Second, my lord, even if it is applied, persons cannot be removed as they are doing.
Yes. Push. My lord, what I understand from my learned friend's submission is that, my lord, he wants that, my lord, the 2021 policy be implemented instead of 2016 policy under which his case was considered, without making a challenge to the 2016 policy. And he also says that this is not a policy at all. Because, my lord, because of the presidential memorandum, this has to be, my lord, in accordance with my lord, whatever my learned friend has submitted, my lord, our answers are there in, my lord, two paragraphs. My lord, paragraph 13 and paragraph 24.
Of your affidavit,
My lord.
page number?
Page 133, my lord, paragraph 13. Without making a challenge to the policy, my lord, he wants to get the benefit of the subsequent policy. And that is the, my lord, what I understand, my lord, subject to correction, that is what his submission is, my lord. Because he did not challenge the 2016 policy. Paragraph 13, may I read, my lord?
Yes.
That the deponent begs to state that the petitioner had completed requisite span of 5 years of service in grade C on 31/12/2020 and accordingly was eligible for promotion with effect from 1/1/2021. However, as per clause 2.2a and clause 2.3b of the opposite policy, only 70% of the eligible executives of the same grade are entitled for promotion to grade D in the current promoting cycle and as per merit, and the remaining 30% eligible executives are to be promoted to grade B from the 1st January of the following years, subject to meeting all the eligibility conditions. Thus, 70% of the executive span is 5 years, whereas 30% of the remaining executive span is 6 years as per policy. In the instant case, although the petitioner's total score as per selection criteria was 90.20, he came under 30% slab as he was displaced by the SC/ST candidate from the merit list on account of applicable concession policy for the SC/ST candidates formulated by the Ministry of Heavy Industries and Public Enterprises, Government of India, wide OM, dated 31/1/2014, Annex 24. Accordingly, the petitioner was promoted by order dated 8/1/2022 with effect from 1/1/2022 instead of with effect from 1/1/2021. It is pertinent to mention herein that the petitioner scored 90.20 out of 100, which was calculated based on Performance Management System and Promotion Policy 2016, that is weightage of APAR and qualification score. The petitioner accepted the promotion order dated 8/1/2022 to grade D with effect from 1/1/2022 as per the existing terms and conditions without any objection by his acceptance, that is 17/1/2022. Now, your lordship will find, my lord, my lord, there is a submission, my lord, there is no limit, there is no vacancy position, that is not correct, my lord. Your lordship will see in the chart, my lord, paragraph 14, that the deponent begs to state that as per the summary of DPC for promotion from grade C to grade D, in the instant case of 1/1/2021 cycle is as under: total number of eligible candidates 192, vacancy with effect from 1/1/2022, it should be 2021, this is a typographical mistake. Vacancy with effect from 1/1/2021 or 70% of the candidates 92. So, my lord, there is a specific number of vacancies, otherwise, my lord, the question of taking him out, my lord, from the earlier list could not have arisen as he was submitting, my lord. Then, my lord, number of candidates posted outside the organization. 4, number of candidates superannuating on 31/12/2021, 0. Total number of vacancy 92.4 is equal to 96. Concession is applicable to eligible SC candidates with seniority of 96 and above. SC candidates promoted with concession 6, including serial number 7 of the table below. Then, my lord, the table has been given that your lordship has already seen. Then your lordship may come to, my lord, paragraph 24.
So these SCSC 6 candidates are the private respondents.
Right. So far as this, my lord, statement is concerned, my lord, in paragraph 13 and 14, 13, my lord, of the affidavit in opposition, that has not been controverted by him, my lord, in his affidavit in reply. Same is the case in respect of paragraph 24 also, my lord, there is no reply to that. That is statements, I am reading paragraph 24, my lord. Page 142.
Yes.
That is statements made in paragraph 19 of the petition are not correct, and as such the same are denied. The deponent states that certain grades in the respondent company, that is G, H, and E, F, are clubbed at the same pay scale, and the higher pay scale, a scale of pay, that is starting at E2 rather than E0 or E1 has been adopted. This was done because of flexibility granted in DPE guidelines for past pay revisions with effect from 1/1/92 and 97, and discontinuation of flexibility in subsequent pay revision guidelines with effect from 1/1/2007 and 1/1/2017 for the sake of clarity, the grade of oil vis-a-vis DPA pay scale and the grades are as under. Now your lordship will find, my lord, C in oil is, my lord, E5 in other CPSC, my lord, published techniques. So this is E5. And this has also not been, my lord, controverted by him in his affidavit in reply. So, my lord, sum and substance is that, my lord, he wants to get the benefit of 2021 policy without challenging the, my lord, 2016 policy. And we have done, my lord, everything as per the policy and the guidelines.
Private respondents are not there, right?
Yes.
Yes, anything?
My lord, the submission by my learned senior, my lord, about there being no fixed number of posts. If my lord comes to the table, which my learned senior had referred to, my lord, page 133, sorry, page 134, my lord. The table total number of eligible candidates is 131. Vacancy with effect from 1/1/21, my lord, as of the typographical error, or 70% of candidates. It is not posts, my lord. It is candidates. Page 134. Total number of eligible candidates. That is what I was submitting, my lord. The persons who are eligible, and vacancy is 70% of the number of candidates, not the posts, my lord. But there is no.
So therefore, there is some fixed number. It's not
Fixed
that
number as per the number of candidates. If there are more candidates in grade C, supposing in first year in 2021, my lord, there are 100 candidates in grade C, then it will be 70%.
And where is the representation,
My-
rejection of your representation,
My-
these numbers?
My lord, from page 85, my lord, there are they have different stages of grievance. Page 85, my lord.
Hmm.
'85 is the first one, my lord. Then from page 86.
Hmm.
86 is the grievance stage 2, my lord. It is 3/4/2021. Then page 89, my lord, is grievance stage 2, my lord, 18/5/2021.
No, where is their response?
My lord, they give it as remarks. If at page, if lordship is at page 89, lordship will see the remarks. We write with reference to grievance number so and so, would like to inform you that concession as per DPOM so and so is applicable in oil based on a grade of an executive, highest grade immediately below board level as per DP is E9, which is equivalent to oil grade 1. Further, grade E5 is equivalent to grade H so and so, my lord.
Yes.
Yes, my lord, this was confirmed at page 90, my lord. Oh, sorry, my lord, 90 is my representation again. On page 91, my.
Yes.
Page 91 is in grievance stage 3, my lord. This is 11/11/2021, my lord. The same remarks, my lord. In oil, grades have been compared with DPE grades in terms of number of levels below board for implementation of concession. Accordingly, the company has been extending benefits of concession to SC candidates based on hierarchy of grades, based on levels below board level. E9 has been taken equivalent to grade 1, E8 to grade H, E7 to grade G, E6 to grade F, and E5 to grade E, and concessions have been extended up to promotion to grade E. As informed earlier, your candidature was duly considered along with other eligible candidates for promotion to grade D with effect from 1/1/21. However, in the merit list of eligible candidates, your name did not figure in the select list 70% after applying selectivity ratio, and as such, DPC was not in a position to recommend your name for promotion to the next higher grade.
Yes. That's all.
Your Lordship, from which one of just one sentence, this order is also not under challenge in the report. This order has also not been challenged.
The junior officer Kyle is present.
You're appearing. Appearance, take the appearance.
Deeply obliged.
Hello.
May it please your lordship. Lordship, we have been informed by the father of the petitioner that the manufacturer of the prosthetic limb has received the fund and it
And the manufacturer has already received the fund. Therefore, on the joint request of learned counsel from both the sides, this matter be listed again after 6 weeks.